Good morning. My name is Rob Johns, and I'm the director at AppleRed Legal Aid. And I'm unfortunately putting the attendees through this again because I forgot to turn the video camera on. But I just briefly want to say welcome, and I want to say again thank you for the trainers who are here. Thank you for the volunteers who are going to help these vulnerable clients in Eastern Kentucky. We appreciate it. And a special thank you to Barbara Silverstone and NOSCR for what they have done in terms of helping with this training, in terms of recruiting attorneys. And again, this is, I think, something that I am very proud to be a part of as a member of the legal profession. And I think that your help is really appreciated. And really the efforts and the volunteers and the response has been overwhelming and inspiring. So again, thank you very much for all that you are doing, and we really appreciate that. And on behalf of AppleRed, NOSCR, and the clients, thank you. I'm going to turn it over now to Barbara Silverstone, who's the director of the National Organization of Social Security Claimants Representatives.
And again, I want to thank you all for coming here. Thank you for watching on the video. Thank the trainers also. I'll just say I'm the executive director of NOSCR, National Organization of Social Security Claimants Representatives. We're a nonprofit organization of about 4,000 attorneys and non-attorney representatives who all represent people who are applying for Social Security, disability, and SSI claims. So the trainers you have today are indeed experts in their field, and I encourage, if any of you become interested in this field, to look us up and join our organization and learn everything there is to know about this practice. So our trainers, we have Tom Moak, an attorney from Kentucky.
Prestonsburg, right?
Prestonsburg, right in the middle of everything. And Deborah Schifrin from Ohio, Charles Hall, North Carolina, and Bruce Billman from Virginia. So we've gathered together to try and give you guys all an overview of what you're going to be facing when you represent these claimants. So I just wanted to set a little bit of the background of how these individuals got into this position. The 1,500 beneficiaries received letters saying that the medical evidence provided by one of the doctors was, Social Security decided was suspect, and they would no longer consider it. So they took that evidence out of their files. If there was other evidence in the individual's files, I believe those people never got letters and they continued on. I'm not 100% sure about that. But if there was no other evidence, then you've got an empty file with no proof of disability. So they got letters saying, now you have to prove that in fact you were disabled back in 2009 or 2010, whenever you first were awarded benefits. So a big issue right now for these hearings is going to be getting relevant medical evidence, getting evidence today from a doctor who can say, my experience based on these conditions, this person was in fact unable to, met the disability standard, unable to lift and different things that they'll all go into back in 2009, 2010. So it's a little bit different than a regular claim, but they're going to go through all the steps of how you argue a regular claim. At the time that all this was going on, there was a huge backlog in Social Security claims. The delays were very, very long, and Social Security was really encouraging the hearing offices to move the claims as quickly as possible. Judge Doherty, the ALJ in all of these cases, was able to move these cases really quickly because evidently nobody ever really saw a doctor or saw a judge or anything. So, but from Social Security's point of view, back at the time, he was lauded for really moving the cases. They weren't really looking at the details, and that's sort of how everything just got run into each other, where he was moving cases and they were happy, and he was getting awards for having so many decisions. The Senate investigated some of the procedures. There were whistleblower acts. They looked further into the procedures and learned that everything was not as above board as it seemed between Eric Kahn, Judge Doherty, and the doctors. There's been no allegation that the claimants themselves had any idea that they were involved in a scheme. There's been a lot of accusations for the doctors, the judge, and the lawyer. And the question that is on everybody's mind is why the lawyer is still able to practice. I don't know. I'm not getting into that part of it. We're focusing on the claimants here. And I mean, that's a huge question, but right now what we're doing is just letting other people deal with that and focusing on representing these claimants in their hearings. So one of Judge Doherty's techniques was to not actually have a hearing, but to do what is called an on-the-record decision, which is permitted in Social Security claims. If the judge looks and sees that there's enough evidence and there's no reason for the claimant to come in, he can just award benefits. An on-the-record decision can only be favorable. So a lot of these were on-the-record decisions. My guess is because of that, it's going to be very unlikely that in these reviews, the judges are going to have any on-the-record decisions. So they are going to be hearings. And they are going to be video hearings from judges from the St. Louis National Hearing Center. Those are judges that do all video hearings. If the claimant objects to a video hearing, those judges will come to Prestonburg and do the hearings in this office. And we are working with Social Security to permit three-way hearings where attorneys can be in another part of the country, the claimants in their home area and the judges in St. Louis. It's not an ideal situation, but it will be able to cover more of the hearings. So that's just the basic background of everything. We're going to get on with the training. I did want to point out the book here, Social Security Disability Guide for Beginners, is donated by the author Amy Foster, and she also said that she was able to have Amazon have this weekend be a free download weekend. So sorry if you're watching it on video, it's not that weekend, but for the live people, you can download it on Kindle. I don't know the details of how that's done, but I'm just saying that. And you can also pick up a hard copy. Charles Hall has also put together a listserv that we will be using to answer questions. So as you folks encounter different situations, we encourage you to share your experiences and also to ask your questions. And I'm encouraging my members to also go on the listserv and answer questions. So you may get answers from more than one person, more than one point of view, and I think that will be very helpful to everybody. So now we will get on to the real training. No, now we're going to talk, Ned is going to talk about a lot of the litigation that has been going on with these cases.
Thank you, Barbara. My name is Ned Pillersdorf. I'm an attorney in private practice in Prestonsburg. I've been a lawyer 34 years. Prestonsburg is in Floyd County. Eric Kahn's office is in Floyd County. Today, I don't think there's a family in Pike or Floyd County who is not dramatically affected by this. We have 1,470 people, according to the SSA, slated for hearings starting in September ending in December. By my calculations, that's 22 a day. Without hyperbole, there is an overwhelming sense of fear, panic, and frankly, great fear of continued suicides as to these frightened people. Let me give you some of the background of it, because it may become relevant when you do these cases, and also the fact that pending before federal judge Thapar is our motion to stop these damn hearings. You know, having said all that, I probably should preface this. My wife tells me I need to go see a doctor because I'm so upset about this. And I say, I don't need to see a doctor. What am I going to tell a doctor? That I'm mad at Eric Kahn, I'm mad at the SSA, I'm worried about my friends and neighbors. I need a judge to fix this. Hopefully we won't need you all. Judge Thapar will rule that our preliminary injunction is well taken and they can't have these hearings. We're expecting a ruling from, frankly, I expected it this week. Hasn't happened. It may come today, it may come Monday. Well, let me kind of back up and give you some background information as to how we got to where we are. Eric Kahn, if you lived in Floyd County, had an unbelievable advertising campaign, very impressive. He basically totally dominated Social Security practice. You could not turn on the TV or radio without his impressive credentials, and he had the second biggest Social Security practice in the country. The Wall Street Journal about 5 years ago did a story that basically suggested that Kahn had a collusive relationship with Judge Daugherty, that the 4 doctors, and this is important, basically was a conveyor belt. They mass-produced reports. Then, during the week of the government shutdown about 2 years ago, the joke was the only thing the Republicans and Democrats in the U.S. Senate could agree on was that Eric Kahn needed to be indicted. They had a hearing, Kahn took the Fifth Amendment, and there was testimony from about a number of his employees. I have interviewed probably 12 of his employees. There have been a number of state court hearings, and here's why it's relevant, all of this. There's obviously going to be issues about the medical records. The uncontradicted testimony at the Senate hearing in Floyd Circuit Court has been that basically when the Social Security Administration served notice to Mr. Kahn, he had a 4-day bonfire behind his office. 12 employees participated, and for 4 days they burned all these people's medical records. It's pretty clear, it's kind of complicated, but it's circumstantial. It's probably of these 1,470 people connected to these 4 doctors. During the congressional investigation, there's a receipt from Shredall that on the Tuesday of this 4-day burn, by the way, the burn was so bad, the neighbors complained about the smoke. There's also a Shredall receipt, 2.2 million documents were shredded, plenty of testimony about computers being hit with hammers, destroyed. Clients today, when they go to Kahn's office to get their records, are basically not getting a very good response. And Kahn's staff, from time to time, actually says, well, go to Ned Pillersdorf's office. He's got your records. When they make those statements, that's what's called lying. It's not true. I cannot understate the trauma these people have gone through to retrieve their records. And 20 years from now, the situation of Melissa Jude, I'll never get over, I'll never forget. Melissa Jude was a low-income lady in Martin County, one county up. She got that letter. This all started basically the Thursday before Memorial Day, May of this year. She got the same letter that 900 other people got. It said, Jude, Miss Jude, your Social Security benefits are suspended immediately. You have 10 days to give us your records. Miss Jude then went to her medical provider in downtown Inez, and she was told, well, we can get you your records, it'll take 30 days. According to her husband, she was actually headed to my office and thought about it, said 10 days, I can't get them for 30 days, this is hopeless. She pulled off on the side of the road, she put a gun in her mouth, and she killed herself. She had little kids. After our Hurricane Katrina hit, it's been really in waves, these 900 letters went out. It was absolute panic in the community. I'll never forget pulling up to the Hardee's to get my breakfast biscuit, and the lady who served me said, you know, there's no one online here, Ned, and you better fix this. Loss of benefits. My boss says we're laying everybody off because these people have already started cutting back. I got to the office, the president of Citizens Bank, the local bank, called, said, Ned, you got to fix this, and put the word out immediately that if those clients got a letter, we're not going to foreclose on them or repossess their cars. And then I got a call from the people at the food bank who were in panic. It was just some of the atmosphere it was. Thereafter, I've never voted for him, but we are lucky that Congressman Hal Rogers, our congressman in the Eastern Kentucky, is head of the Appropriations Committee. Once the suicide started, it shook Congressman Rogers up. And what Rogers told me, and it's kind of why we're here today, he said that basically it was the lawyers in the Social Security Administration who were pushing for this, what I call punitive action against these people. Basically, I don't really understand this, probably Barbara does, but the politics in Washington is there's currently a dispute in Congress as to moving Social Security money from one area to another, and the agreement was we'll do that only if we crack down on the fraud. Well, who's the poster boy for the fraud? Well, Eric Kahn's been in the Wall Street Journal, been on 60 Minutes, I think they've run it twice. And so basically this was a decision to show the world that we're cracking down on the fraud. Can't say this more importantly, there is zero evidence that any of these 1,470 people had any idea anything unusual was going on. In fact, I've yet to meet the first client who actually met Kahn. The testimony has been from his employees that he was sort of this hermetic character, would not interact with the clients certainly, would only interact with 2 or 3 staff members of the 40 he had, spent a lot of time in Asia with his Asian fiancés, plural. He's a brilliant guy, he's a Mensa member, and he hasn't been indicted, he hasn't been disbarred. When you meet with the clients, and I've had a lot of open meetings with these large groups, emotionally these people think if Kahn gets indicted, if he gets disbarred, their problems go away. Well, of course, that's not true, but when you meet these people, you will encounter the palpable anger they have. Where we are now is Congressman Rogers, and he was wonderful. I mean, he was calling me back and forth on his cell phone. He went over the head of the Social Security Administration lawyers, and by the way, that's who I think is the real people out to get these folks, is the lawyers in the SSA. Rogers went over their head and walked into Carolyn Colvin's office. She's the Commissioner of Social Security. And he writes her budget, and he got it fixed. He got the benefits restored. But what Rogers told me, he said, Ned, the pushbacks are going to be they're going to want to set all these people for hearings, and they're coming after your folks. And then we got word about a month ago, this September to December brewing attack. When the way I communicate with my folks, by the way, and when I had these open meetings with them, is the agreement was I have a public Facebook page and I post Eric Kahn fiasco updates. The reason I do that, frankly, is these suicides, these people threatening to commit suicide. This has been the worst part of it. If you check my Facebook, I think the day before yesterday, there was another suicide note there. About a month ago, I had to call 911. This guy posted a suicide note. I called 911, the state police went out, I read them the suicide note, and I'll never forget the 911 operator said, oh my, they can do a welfare check on these people. But the suicide problem is very, very real. These are terrified people. I mean, this has been the worst 3 months of my legal career. I mean, and you know, I'm feeling probably 1/100th the pressure these folks are. We've got 2 heroes over here. This is Cheryl Martin and Robert Q. Martin. They're not related. They both have significant cancer issues. Cheryl has testified in court that she's a terminal cancer patient. When all this commotion was going on, Cheryl's been in the office. I think she previously worked in like the West Virginia court system and is good with dealing with people. But she has dealt with these terrified people, and I cannot stress terrified. For those of you unfamiliar with Kentucky, and where Floyd County is, I think 4 of the 10 poorest counties in the nation are near Floyd County. Somehow at one point, Floyd County had the distinction of having the highest juvenile poverty rate in the country. So that's the kind of atmosphere we're operating in. There is 2 pieces of federal legislation you all need to be aware of. The first is the KTAM action that I am not involved in. The name of that case is Jennifer Griffith versus Eric C. Kahn. If you go to Federal Pacer, Eastern District of Kentucky, my friend Mark Olander is doing that case. That's the whistleblower case, and at the risk of grossly oversimplifying the case, 2 bureaucrats in the Huntington office have sued Kahn under a federal whistleblower claim, or KTAM. It's a 47-page opinion by Judge Thapar. What's significant in that opinion, and by the way, let me back up a little bit. There were news reports about that opinion that indicated it was a great victory for Kahn. That's nonsense. What that opinion says is significant, and it may be significant in that in terms of anybody in possible attorney fees. Here's where we are. To practice in Social Security, this is according to Thapar's opinion, you need more than a valid Kentucky law license or whatever. You need to be able to certify, and there's a box, that you have not been disqualified from a federal program. What the whistleblower said was, hey, Eric Kahn 4 years ago was under investigation by the Veterans Court, and prior to him being kicked out, suspended, removed from the federal court, however you call it, he resigned from the Veterans Court. Now, if you're under investigation and you resign, does that equal being disqualified? Judge Thapar said yes. He analyzed that. To me, that's significant in that he rejected Kahn's argument. Kahn says, I was never disqualified, I resigned. And actually, Judge Thapar made a little joke about it. He said it's like somebody going to trial getting convicted and then trying to get a benefit by then trying to plead guilty. So immediately after I read that opinion, and some smarter people than me talked to me about it, the light went on in my head. Of these 1,470 people, probably he got $6,000 each, correct? If you do the math, 1,470 times 6,000, that's 9 million. I immediately amended the state court complaints to say my clients want their attorney fee back, because if you read Thapar's opinion, what he appears to be saying is Kahn was not entitled to the attorney fee. Okay? So that's out there, and if you read that opinion, you'll get some good background. Probably the most important legal proceeding involving this group here is right after this horrible Memorial Day hit, we immediately filed preliminary injunction motions. The name of the case is Cheryl Martin, C-H-E-R-Y-L Martin versus SSA. You need to type in Cheryl's name because plenty of cases against the SSA. That is the case that's pending now. But frankly, I hope we don't need you all if we can win it. It started out as a preliminary injunction motion when the benefits were suspended for the 900 SSDs. The 600 SSIs, they did not suspend their benefits. There was scheduled to be a hearing the following Friday, and on Wednesday I got all these phone calls from Congressman Rogers. He asked me what my chances were for this emergency hearing. I said I didn't know. And on Thursday he fixed it and there was a press conference. We then amended the lawsuit, so when you start reading this you'll be clear, to say they have no right to subject these 1,470 people to hearings. And why this is important, and you need to monitor the lawsuit, it would not surprise me, based on the 50-minute oral argument we had with Judge Thapar 2 weeks ago, that if he didn't rewrite the rules for everything we're going to be doing. And I don't know where he's going. For 10 minutes during the oral argument, I was absolutely convinced we were going to win. Not on the issue I thought we'd win on, but on another issue. I'll get to that. And for 10 minutes, he frank out just drilled me. And You know, by the way, I could not be more proud of the pleadings the incredible legal team we have assembled has put together, Anne Marie Reagan, John Rosenberg, and others. I'd like to take credit for that. I probably wrote 10% of it. But let me just get to what Judge Thapar was talking about. By the way, he's a federal district judge who's in charge of the case. I thought going into the argument into the hearing on our motion of preliminary injunction to stop these damn hearings, pardon my language, was that, hey, all of these people have been subject to CDRs. The alleged con fraud 08, 09, 010 took place then. Robert, when was your CDR, your last one?
In 2012.
And you sent in your cancer stuff when they left you alone, right? Okay.
Yes.
So basically there's
Explain what that means.
a CDR that's a good question, is a continued disability review, and that's a big deal. In other words, Mr. Martin or others in the group, and it looks like most of this group have had CDRs, have been re-examined either by Social Security doctors, or in Mr. Martin's case, I think he just sent them your chemotherapy records and they left you alone, right? So we basically argued to Judge Thapar, Judge, they've already been reevaluated since. Why do you penalize them? And Thapar basically told me, Ned, you're not getting anywhere with that argument. What he said is, Ned, the argument you're making about the CDR, when you represent all 1,470 of these people, that'll be persuasive evidence to the ALJ judge. And then he said, I read something in the newspaper where they're all represented by Morgan & Morgan. And I said, first of all, Judge, we're not likely to get lawyers for 1,470. Bless you all being here. But fair warning, folks, you're likely not to get paid. These are complex cases. And after you do 2 or 3 and realize what the heck you're getting into. But Judge Thapar, I hope I set him straight on that, but he was not sympathetic to that argument and said so. The argument the argument, and this is going to be important if we do these hearings, that he seemed persuaded on, the first words out of his mouth is, he said to the SSA lawyer, how can you put these people through hearings when you have, the way you've got this hearing set up, or I would say rigged, you have unchallengeable evidence. The unchallengeable evidence is that basically the way these hearings are set up is they're basically placing a 0 next to the 4 suspect doctors referenced in the letters everybody got. We're expecting a ruling from Judge Thapar. It could be good, it could be bad, but it would not surprise me if he didn't even rewrite the rules for some of these hearings. He's clearly bothered by the fact that how can you have a, quote, a fair hearing and have unchallengeable evidence? So that's what's out there. And my only closing words to you is, I mean, this is a tremendous battle for people in my area. I can't thank any of you who does any of these cases to help these people. I really thank you. Appreciate it.
Folks, my name's Tom Moak. I'm an attorney in Prestonsburg. Been practicing for roughly close to 30 years. Do a lot of Social Security. I'm going to try and give you kind of an outline of where I think we're at in terms of these particular cases, and then be a little bit more specific about just some suggestions, recommendations. My understanding is there are some people in this room that have not handled many Social Security cases. Is that right? Are there some folks that have not handled any? Okay, well then, welcome to the party. Couple of things just real quick. This group of cases that we're talking about here, these roughly 1,500, they are not typical cases. I have been talking to people that have come through the office. I've talked to maybe, I don't know, 30 or 40 of them. Some I've had come in the office, some only over the phone. I've been looking at them like any other case. When I have them come in, I sit down, I talk to them, try and get as much information as I can, see if I can help them. Some of these are not very good cases. Some of these folks, when they were approved, were 35, 40 years old. They had a bad knee, they had a bad back. They probably should never have qualified for benefits. But a lot of these folks, their initial opinion was in 2007, 2008. Here we are 6, 7, 8 years later, and they find themselves in a predicament that is just a whole, something that they need representation. What I've been doing is trying to talk to people. If I think I can help them, I tell them that. Quite frankly, if I tell them if I don't think I can help them, I tell them that as well. So keep that in mind when you actually sit down and talk to these folks. If you in good conscience don't think you can help them, if you don't think the evidence supports their decision, I don't think there's any problem with telling them that. At the same time, it doesn't hurt to give them a fair hearing before they get hung. That's what I think is going to happen to a lot of these people. A couple of things about these particular cases that I think is important that you have to understand. I've never seen anything like this. I do a lot of Social Security, but basically what they've done, what Social Security has said, is that there was fraud between Eric Kahn and the doctors. The allegation is that Kahn, basically his staff prepared the reports and the doctor signed off on them. And they handed those reports to Judge Daugherty, and Judge Daugherty approved the claim. What's unusual is that Social Security has taken the position that there was fraud in every case, that in 1,500 cases there was fraud. They have not shown any evidence of fraud. I have not seen anything that says in this particular case there was fraud because we found that this report was phonied up on this particular day by this particular doctor. What I have done in my cases, and I've got maybe 15 or 20 of them right now that we're getting ready to see what we can do with. I have filed a letter to Social Security asking for a copy of the Inspector General's report. Did it just like you do any other request for information. I got back this real nice letter, Ned may have a copy of it, that said, no, you're not allowed to see it. It's freedom of information. Here's 15 different exceptions. Basically what they said is this was still under investigation. So we're not going to show you the report. Based on that letter, I have filed a motion to bifurcate my cases. What I am saying to the judge is I want a hearing on fraud first. I don't think you have shown me enough proof in my case that we should have a hearing on the merits until there's a decision on the fraud. I don't think a Social Security judge is going to pay any attention to that. But I'm trying to protect the record and try to raise some more issues because some of these things may end up on appeal. To back up a little bit, the way these cases work, typically somebody comes in, they file their claim, they get denied, you request an appeal. The initial appeal is called a request for reconsideration. Their case then gets reviewed by an office that is either in Frankfurt or in London and different places throughout the state and actually throughout the area. It's called disability determinations. What they do is they look at the medical evidence very quickly. If they think they qualify, they approve it. If they deny it, they send them a letter that says your reconsideration request has been denied. The next step for those folks, and this is for everybody that does a Social Security case, you then request a hearing. The hearing, what that means is your case then gets transferred to a hearing office, and then you have the opportunity to submit all of your evidence to the judge. And the decision that the judge makes is, are you eligible for Social Security? And there's two kinds of Social Security. These folks will get into this in a little bit more detail here in a minute. There's SSI and there's Social Security Disability. This is all very abbreviated, but SSI is basically for people that have not worked enough to qualify for disability. Disability means you have worked, you've paid in Social Security, you qualify for Social Security Disability Insurance. If you have worked, I think for 5 years, you qualify for disability for a certain period of time. The period of time that you qualify for, the last day that you qualify for full disability is called your date of last insured. Other folks qualify for just SSI. Those are folks that have not worked enough or meet other earnings requirements. SSI is for basically poor people that have not worked enough to qualify for disability. When you end up in front of a judge, they don't care specifically whether it's disability or SSI. Their main focus is whether these individuals qualify for disability. So the standard for SSI and disability is the same. But what I plan to do in my cases is raise some of these, what I consider to be jurisdictional issues. I'm filing a motion to bifurcate and asking for a hearing on fraud first. I'm also filing a motion to hold these cases in abeyance until I get to see a copy of this Inspector General's report. Now today, for the first time, I think Barbara or somebody showed me that in one of the files they were looking at, there was a memo from Social Security to Social Security that said, we have determined there's fraud in this case, and it referenced that Inspector General's report. It looked like just kind of a memo, kind of a brief summary, and all it said is the same thing that all these other cases or all these other letters say. These folks all got letters from Social Security that said, we've found fraud in your case, and fraud involving 4 different doctors, Dr. Herr, Dr. Huffnagel, Dr. Atkins, and Dr. Amicetti. Atkins is a psychologist. He would say whatever Kahn's office wanted him to say. Herr would say whatever Kahn's office wanted him to say. Huffnagel is now deceased. Amicetti did basically the same thing. My understanding is, in looking at the Senate report, is a lot of the fraud didn't get started in earnest until maybe 2010, 2011. And the idea, I guess from Kahn's perspective, is it was just too much trouble to waste time actually sending these folks to a doctor, waiting on the doctor to do the report. It's much more efficient if my office summarizes the medical, fills out the report, hands it to the doctor, gets the doctor to sign it, I send it in. It works a lot better if you don't have to go through the actual hassle of having a doctor actually examine somebody. So they were just cranking these things out. They would schedule 20 or 30 appointments, doctors would generate the reports. But in talking to some of the folks that I've talked to, that their initial decision was back in 07 and 08, they say that they actually went to the doctor. They say that they saw Dr. Herr or they saw Dr. Huffnagel. And I've had people say, and I intend to offer them or have them testify, that doctor did a great job. He did a full examination. He looked at their medical records. He talked to them. He did a physical exam. In fact, I've had one lady say that what one of the doctors told her was a better diagnosis than what her family doctor had told her. So at least some of these folks may testify, and you need to ask them, did Herr, did Huffnagel, did Atkins, did Amicetti do a real exam? Did they see you? Did they ask you questions, just like any other doctor? And again, I think it's important because if we can show that in 2007 or 2008, there maybe wasn't as much fraud as 2010, 2011, that may open the door a bit to at least having some way to challenge the fraud. I'm no constitutional scholar, but what Ned's been arguing is Social Security says there's fraud, but these people have not had a chance to challenge that. There's never been a hearing. There's never been any evidence presented. And again, the little I know about due process is you're supposed to have a meaningful opportunity to be heard and look at the evidence that is presented against them. So again, just as kind of a threshold question in these particular cases, I intend to file that motion, and I will share that motion, both my motion to bifurcate and my motion to hold in abeyance with everybody. Part of what I think you all need to understand in these cases, and these folks will talk to you a little bit more about the mechanics about getting medical records and getting these cases ready. But what you're trying to do in this case and in any Social Security case is build a record. And in these cases in particular, I think it's important that you raise these issues as a threshold matter so that you can preserve the record for appeal. Because a lot of these folks are going to have hearings, a lot of these folks are going to get denied. And then the next step after you have a hearing is you can then request a review by the Appeals Council. The Appeals Council is basically an administrative review board that looks at the procedure. They don't necessarily look at the merits. If they think everything was correct, then they basically affirm what the judge did. Once the Appeals Council makes a decision, you can then appeal that into federal district court. The standard is a kind of a basic standard of review. And from there, you could appeal it into the Sixth Circuit. There's a chance that some of these cases, once the initial ones come through, somebody's going to file an appeal some of these appeals could be consolidated. So again, I think it's important to raise some of these issues as a threshold matter. I'm going to talk just real quick and kind of give you a summary of how I put these cases together. Then I'm going to hand it off and let some other folks talk about some more specifics. I have given you all a couple of my worksheets that I use on these cases. I'm just going to talk to you about a couple of these forms real quick. The first one is a form I use called a Social Security File Review. That's in this packet here. It's the second page of my Social Security hearing outline. This is a form that I use when people come in before a hearing is scheduled. And what I do is I go through this form and try and get an idea what their issues are. And what I'm trying to explain to the client, and this is what I think is important for you all to understand, in a Social Security case, what you're trying to prove is that these people are not able to work on a full-time basis. We don't have to prove that they're bedfast. We don't have to prove that they're in a wheelchair. What we've got to be able to show is they can't work full-time. Now, if they can do some things on a part-time basis, that's not considered substantial gainful activity, which is the big word that Social Security uses to determine whether they're disabled or not. When they come to see me, what I do is I go through. My first thing is I say, what's the biggest problem that keeps you from working? My back, my neck, my arms, my legs. And then I go through and ask the second thing. What's the second biggest problem that you've got? What's the third biggest problem? And you first need a list of what their impairments are, what their conditions are. Then I ask about other problems. And the reason that's important is Social Security is supposed to look at everything that might bother somebody. Even though one particular problem may not be enough to consider them disabled, if you add a bad back with diabetes and a learning disability, that combination of things may qualify for somebody with a disability. I then ask about if they've had any treatment for anxiety, depression, and stress. If they are having symptoms of anxiety, depression, or stress, and they've never sought treatment for that, I encourage them to seek treatment for that for two reasons. One, they might get benefit from treatment, and two, it's important that they document any problems they're having. The whole point of a Social Security case is you're trying to document any problems they're having, both physically and mentally. Then I go through and ask who's your main doctor. This is just standard information, but this kind of gives you an outline. What specialists, what appointments have you got? Have you had recent diagnostic testing? Have you had recent hospitalizations? And then I ask them kind of a catch-all question. Is there anything new or different that if you went to your doctor, you're not real sure what's going on, you're starting to have headaches, you feel bad, you're tired? Because a lot of times these folks, they get in the trap to where when they see doctors, the doctor only talks about the diagnosis that's listed on the form. Back pain, diabetes. A lot of these folks have strange symptoms. Their legs numb. They don't know why their legs numb. But, to them that's a big deal. So I try to get them to tell me the other stuff. The headaches, the nausea, whatever it happens to be. Moving ahead real fast on this, once these cases get set for a hearing, what I do is I bring my clients in and I go through this Social Security worksheet with them. That's the first page of that form you've got. And again, a lot of this is background information. When you have a hearing in front of a judge, a lot of judges have a checklist. They're going to go through their checklist. Some judges say, you're witness, and they want you to ask all the questions. Either way, all of this information needs to be presented to the judge. The other thing that I think is important about these particular cases is I don't think we can assume that the judge knows anything about the case. I would not assume the judge has looked at the file. So I would go through all of the information, name, age, education, height, weight, all that good stuff. Ability to read and write. Some of these folks can't read and write. They don't want to tell you that. So you got to be a little gentle in how you ask that. Good, fair, poor, and you kind of lean in that direction and you can see them nod. If they have learning disabilities, if they had trouble in school, you can request their school records. That's pretty standard information that you can get A lot of times there's good stuff in school records if you've got time to get it. Go through your work history with them. A lot of these folks will have spotty work histories. They're not going to have worked 30 years underground. We're talking about folks that may have worked a couple of years at McDonald's, that kind of stuff. But you need their work history. And again, generally Social Security looks for the past 15 years as the relevant work that they may have done. Then you kind of go through with them, and then again, this is what I do with my clients before a hearing, is I walk them through the questions that are going to be asked at the hearing. And this is the form that I use. The judge is going to ask you about your work history. The judge is going to ask you about your physical problems. And hopefully the physical problems are the same ones they told you about when you first saw them. Go through the same thing about, how much can you lift and bend, and I'll talk a little bit more about that in a minute. But this is just an outline that I use. There's two other forms that I'm going to show you real quick, and then I'm going to step aside and let somebody else talk for a minute. The one form that I use that I think is as important as any form is this Social Security interrogatories for examining physicians. This is what I call a 4-page report. It's actually 5 pages, but we always call it the 4-page report. This is exactly the information the judge will be relying on when he or she makes a decision. And it's pretty simple stuff. In your opinion, does this individual have limitations? And ask the doctor for specifics. The next page asks the doctor for an opinion. How much do you think this person can lift? How long do you think they can stand? How long can they sit? These are called exertional limitations. In other words, physical limitations that might affect somebody's ability to work. Now, the problem in these cases is you may get a doctor today to say this individual has these restrictions. What's important in these cases, you're trying to figure out what their capacity was, what they call residual functional capacity was. That just simply means what restrictions they've got, was when the first hearing was held back in 2007, or when they first said they were disabled back in 2006. So you're trying to go back in time. That's hard to do. At the same time, you may be able to get your doctor if you can have cooperating doctors. And a lot of times doctors are gun shy about filling out these reports because they'll say, I've not done a functional capacity evaluation. I'm not qualified to give this opinion. You need to, if you can talk to the doctor or get your client to talk to the doctor, explain, all we're asking for is your opinion. You're a medical expert. The judge needs to know what you think. How much do you think this person can lift? How much do you think they can bend? It doesn't have to be exactly what they can do, but this is important information. But in these particular cases, you also need a letter or some way to explain that they had these restrictions way back when. So that's going to be a challenge. And that's going to be, in some cases, impossible to do. That you're going to have somebody that's treating now, they may have seen 5 or 6 different doctors in the last 6 or 8 years. But if you can have a doctor that says, based on my training and experience, they've got this diagnosis, they've got these problems, I've seen this MRI, I've seen these tests, they likely have these restrictions now, and these restrictions probably started 2 years ago, 5 years ago. That's going to be real important. The onset, when their disability started, is going to be the whole key to all these cases. But again, this is a good form that the doctor can fill out. There are other forms like this. You can find forms online. You can create your own forms. It doesn't matter. Just don't fill it out and have the doctor sign it. That's probably not a good thing. But this is the type of information you're looking for. Now, the other form that we use is a 2-page ability to do work-related activities mental. This is for people with stress, anxiety, depression, and most of these folks will have those problems. Again, what you're trying to do is get a mental health professional. A lot of times these folks are seeing PAs or nurse practitioners. Social Security says they won't give as much weight to those mental health professionals as they do a doctor or psychiatrist. Do the best you can. Get as much information as you can. But what's important here is They're asking the doctor, do these people have problems on the job? Can they follow work rules? Can they relate to coworkers? These are what are called non-exertional impairments. In other words, these are non-physical impairments. These are just as important as physical limitations. And again, what you're trying to do in these cases is you're trying to package up the medical evidence and present it to the judge. And the goal of that is to try to show the judge that these individuals have restrictions that keep them from working full time. If, in a lot of these cases, you'll have a stack of medical records. They've seen doctors, they've had hospital records, they've got MRIs. You may have a stack of medical records 6 inches thick. Those records may not help you unless there are restrictions in those reports. If there are just diagnoses, just a long list of treatment, the judge is not going to take the time to basically synthesize that into the restrictions that you need. So the whole point of trying to gather all these records that we'll talk about here in a minute is to package them up with a nice little bow on it and have restrictions. You need restrictions from a doctor. Again, if you can have a doctor that's treated this individual for 6 years offer an opinion, that's going to be dynamite. I've got one case right now where the guy brought me in a letter from his doctor that said, I've treated this individual since 2006. When he came to see me, he had this diagnosis. He had these findings. We ran these tests. I've continued to treat this individual for the past 6 years. They still have these problems. That letter is going to be what you need in every case. You're not going to be able to get that in every case, but that's the goal, is to try and package up your medical. Yes, sir.
What about those folks that can't find
What about the folks that you can't find their medical records?
Are there any physicians that have a willingness to work with this group?
Yeah. Yeah. The question was, what if you can't get that opinion, or you can't get their medical records? That's going to be a challenge in these cases, and probably at least a third of these folks are going to have incomplete medical records. That's just the way it's going to be. You're just going to have to do the best you can with what you've got. The idea is when they come to see you, and I don't want to go too long because there's other folks behind me, but when they come in to see you, either on, in person or over the phone, and you do your intake, you'll get a medical authorization, you'll request their medical records. All you can do is request their medical records. Try and get them from every source they've got. Try and figure out who their doctor is, who their doctor was. Send them a letter, and send it a simple letter that says, I represent so-and-so. I'm doing this for free. I need your help. I need a one-page letter that tells me what you think about this person. I don't need a book. This is nothing complicated. Try to help this person. The problem with our treating doctors these days, they get that same letter from every patient they've got. Every patient comes in, they need a form for insurance, they need a form for disability, they need a form for workers' comp. The doctors will tell you they don't practice medicine, they fill out forms, and they hate it. So, sometimes you're just not going to be able to get that information. It's possible you could hand your records off to a doctor that would do a records review. There are doctors that do that for a fee. Now, if you can find somebody that's willing to do that for free, that's possible. But again, that may take a separate effort from Ned or John Rosenberg or somebody to maybe contact doctors at UK or Pikeville College has a medical school. That's a good idea, but that's going to be a challenge to do that. But again, my point is the reason you're gathering medical records is to show what restrictions they've got, to show they can't work full time. That's what all these regulations and all this other stuff boils down to. But I'll hand it off to somebody else. One other thing real quick. I'm in Prestonsburg. I have a nice office. If anybody needs space in Prestonsburg to meet with somebody, you're welcome to use my office. You don't even have to make an appointment. Just come in if you can find space available. We've got fax and internet and all that good stuff. We've got a copy machine. Because I assume a lot of your people are going to be up there, and unless you expect them to drive down here, just as a matter of logistics, you're welcome to use my office. You're also welcome to call me with specific questions. My information may be in some of these materials. I'm not too hard to find. I'm on TV some, but not.
Let me ask you a question. Now, this is a question I get all the time. A lot of us who are trial attorneys say, well, we got this doctor's report. Do we need to take the doctor's deposition? Does it have to be an affidavit form, or will a simple letter from a doctor do?
Okay.
How's that game get
Okay.
played?
Social Security is an administrative practice. Basically, you can hand anything to the judge and he's supposed to consider it. He or she's supposed to consider it. Doesn't matter. Any form, a letter, an affidavit, interrogatories, a checklist, medical records, copies of MRIs. You can also get statements from friends or family. I encourage that a lot. If, you know, they always say, can I bring my mom in to testify? I don't like bringing in other live witnesses, but I do encourage them to get a statement from friends or family. Write out a page of what you see and observe that these people have problems with. I don't need a book. I don't need 5 pages the judge is not going to read. I need 1 page with detailed information. But you can hand anything into Social Security. They're supposed to consider it. Now, the weight they give it may be different, because obviously if it's, you know, illegible treatment notes, they're not going to pay as much attention to that as they will a typewritten letter. But in these cases, and again, these are not typical cases. You know, one of these days you may get a good case. These are not, by and large, good cases. So that's part of the challenge. Yes, sir.
With the question about the missing medical records, you can't get your clients all of their medical records together. It really, I guess it's got to be missing evidence. Will the Social Security judge, will they weigh it against your client, or would they weigh it in favor of it benefiting your client?
Again, I think that's one of the things that's going to be important in these cases. The question is, how will the judges look at missing evidence or evidence that you're not able to obtain? What's interesting about these cases, Social Security is supposed to be non-adversarial. There's not a lawyer on the other side of the table. When you walk into a hearing, there is a table like this. You sit here, your client sits here, a vocational expert either sits here or is somewhere on the phone or with the judge, and there's a hearing assistant that runs a tape recorder and a video, and they don't video it, but I guess they tape it. There's not a video recording. And then more and more judges are on TV. The idea is it's non-adversarial. You're supposed to be able to hand it in. We're all working for the same thing, blah, blah, blah. These judges are generally hostile to the claimant. They're hostile to the attorneys. They're hostile to the claims. I don't know why. That's just the attitude that I get. I think it's important in these cases that we try to develop the approach with our judges to say, gosh, Judge, I hate that they're making you do this. You know, you shouldn't be doing this. Social Security shouldn't put you in this position. Here's problems we're having with this case. We've requested medical records. The doctor says they changed over from written records to computer records in 2010. Those old records are not available. That is when everybody went to, you know, more computerized records, old records are unavailable, or they were, you know, shipped off to somewhere. That happens every day. But I think you explained that to the judge. Your client can testify who they saw, what treatment they had. Technically, the judge can only consider the evidence in the record. But again, I think you raise that as an issue. And again, you're trying to get the judge to kind of get on your side, so to speak, or at least recognize that there's challenges. So that's going to be one of the issues. There was another question in back.
I guess my questions are for Dan. Is your purpose to prove that the person is disabled now, or was disabled 6 years ago? When you first got to the
Okay, in these cases, and in these cases more than most, you try to prove that they were disabled then, back in the day. Okay, because in these cases, what Social Security has said is the prior decision has been set aside. It's gone. There was no hearing. Like one of these folks said, we're treating these cases as if you're starting the day before they had a hearing last time. You're starting all over. And in many cases, you're starting all over from scratch. We can't assume that they have any of the prior medical evidence, or they have any of the prior testimony, or they have anything to go on. So you're trying to prove they became disabled as early as you can. Now, in some cases, that's going to be impossible, because you're not going to have the kind of detailed information, the restrictions, the impairments, the medical records to back that up. But again, these folks will talk a little bit more about how that's important. For a disability case, you have to prove they became disabled before their date of last insured, before their insurance status ran out. So they may say that they became disabled in 2008. If their disability status runs out in 2010 or 2012, as long as they're found disabled within that window, then they may be okay.
What about the Medicare status?
That's going to be a whole different ballgame. The other thing is, if they say they were not disabled in 2008, 2009, and became disabled in 2010, then Social Security is going to say that they may owe some money back. There's going to be an overpayment. That's a different thing that we can talk about later. Generally, the short version with overpayments is, if you can prove you're without fault and you can't afford to pay it back or it would be a hardship, Social Security will waive recovery of the overpayment. I'm not too worried about overpayments in these cases. What I am worried about is Social Security wants to generate a big number saying that we've recovered $30 million from fraud, but as far as actually getting money back, that's a whole different ballgame. Now with SSI, as long as they are still meet the standard for SSI, when they became disabled makes a lot less difference. Now, what a lot of these folks here today will tell you is you need to have your client check with the local district office if they can file a new claim so that they've got 2 claims pending. That way, they may lose on the old case, they may win on a new case. So that, but
Is your claimant, if the review is based upon fraud, is your claimant exposed to a criminal?
well, again, if your client committed fraud, that's not a good thing. I've been asking people,
How do you put them on?
the question is, what risk is the client as far as their exposure to criminal charges or fraud? I have not seen any evidence or testimony, Ned says he's not seen any, that any of these particular people were in on the deal, in on the scheme, that they knew what they were doing was fraudulent. Now there's a suggestion, I'm sorry?
What if the person never went to the doctor? If the ALJ says, did you go see Dr. Upnagel? And says,
Well,
"That's on my life."
well,
Most of these people didn't have hearings.
a lot of these people didn't have hearings. They don't understand, some of these people knew the fix was in. There's no doubt about that. But having said that, a lot of these people say, I went to Eric Kahn, he's a lawyer, I handed my records, there was a report from a doctor, I assume the doctor reviewed my records, somebody reviewed my records, I don't know. You treat that like any other issue, you don't want your client getting themselves in trouble. But a lot of these people will testify they did not know how things worked. These folks are, to a certain extent, vulnerable. Some of these folks are more sophisticated. They understand how this system works.
Tom, do you know whether the ALJ, have they tried to pry into what the claimant knew about what Eric Kahn did for him?
Well, again, I think in general on these cases, the judges are not going to get into that. Because I don't think there's going to be a fraud as an issue. I think on these cases, the only issue is going to be disability. So, and that's probably a good point. The question was, how do you handle the fraud issue? I think in general, the judge is going to tell you up front, I don't want to hear anything about that. All I want to hear about is your condition, your medical records, what treatment you had, what problems you had. Some more questions?
Okay, Ann May from Pikeville. For those of you all that are not from our region, be aware that most of the physician offices in Pikeville have been purchased by Pikeville Medical Center. A lot of the old records are housed there. The hospital has taken the position, as Ned has said, it is a catastrophe for our region. They are providing copies of those medical records at no charge. If you alert the medical records custodian, they will turn those records around hopefully within 24 hours for you, so that you can get those, because they're right, the old rule is 30 days you'll have it in your hands. So be sure if you request records, you spell out that you're requesting for these cases, you understand there is no charge, and you ask that they be expedited for you, which will help because a lot of the doctors are there. Also, it would be helpful in Ron's area, we know there's.
Pam, I'm going to stop you for 1 second.
Yeah.
Would you come up real quickly and
Yeah.
do that on camera?
Yeah.
That would be very helpful.
Let me just say one other thing about requesting records. Kentucky law says the client can request a free copy of their medical records. And the medical provider is not supposed to charge for that. The problem in a lot of these cases is these records have been requested multiple times. So there may be a bill for a record, that these people request. Again, I think you have your client or you send us a letter that says, this is a special circumstance. We really, really need these records, and I understand your fee is $50 or $75. Can you waive it in this case? And it may take a call from your nice secretary to somebody else's nice office manager to get that done.
They say no, do you have a source? Is there any common source
No.
for our firm?
Now the question is, what if you can't get the records for free? Do the best you can. So.
The point I was trying to make is many of these cases will come out of Pike and Floyd County, some out of Martin. The main hospital, or the largest hospital in the region, is Pikeville Medical Center, formerly Pikeville Methodist Hospital. For the past 6 to 8 years, the hospital has been acquiring a lot of the physician practices. Most of those records were incorporated in hospital records, or at least are being stored by the hospital. The medical records custodian there clearly knows what has been brought in and what hasn't. So the hospital has also, because of the nature of the problem involved in this very unique situation, offered to work with the claimants to get their records quickly. So if you request records from Pikeville Medical Center, and that's probably for anybody from the region, I would at least start there. Identify up front that you are representing a client that has been part of this situation, and ask that those records be expedited to you back within 24 hours. They will try to do that, and the hospital has determined there will be no charge for those. By the same token, can we post something that identifies the doctors that are working at the hospital, that work for the hospital, because they have a unified record, and rather than having to send out records to 6 or 8 offices and them all going back to one central location, we should be able to expedite this a little bit for that region. Okay?
Let's talk
So
about it.
I'm
Okay.
hearing from this side that they will be able to post something for you. The other thing I would like to see is, if we can get together, is those of us that work, Ned, Tom, we know which doctors are out of practice and records aren't available. Nick Rochelle is not available. There's no point y'all spending time trying to find them. And if you see his name, you know you're going to have to go somewhere else and try to do something else quickly. So if we could get a list of those doctors put together, I think it would help. If you all are honestly telling me September hearings, that's a real eye-opener for some of us sitting in the back of the room. Thank you all.
Ma'am, identify yourself, people on video so they know you.
No, I've been asked to identify myself for purposes of letting you know who I am. My name is Pam May. I work with Pam May Law Firm in Pikeville, Kentucky. If you hit snafus in Pikeville or the region, my phone number is 606-432-0400. Email is ptmay@pammaylaw.com. It scared me to learn that I've actually been in practice longer than Ned over here. I feel like I look a whole lot younger than Ned. But having spent 38 years working on the side of basically representing doctors, hospitals, and healthcare providers for 38 years, we'll be glad to be a resource for those of you that are perhaps coming from out of region trying to figure out what's going on up there. So if you hit a barrier, to the extent we can, we'll be glad to do that. Realizing at the same time, we're going to be going back to you all saying, oh my gosh, what do you do in these cases? So thank you all.
By the way, let me tell you a funny anecdote. As I understand, your clients know that Pam May's, I shouldn't say Pam May, that Pikeville Medical Center, you have posted public service announcements. Your clients will know that. One of the hilarious things, to give everybody notice here, Mr. Khan's response to this publicity has been threatening to sue everybody, including, you know, your hospital cast him in a false light. He's threatened to sue WYMT. He's threatened to sue, I've had several doctors call me or in fights with him over records. So don't be surprised if you get a call from Mr. Khan, and we should not cast him in a false light, okay?
Could you or one of the others talk about, a lot of these clients are getting CDs with their medical records on them.
Okay, I may let somebody else speak to that.
Yeah.
Yeah, okay. Just real quick, again, my name's Tom Moak, Moak and Nunnery, Prestonsburg, Kentucky. 606-886-1515, 1-800-248-1440. Email is mope41653@aol.com. Thank you all.
All right, never talk to a tired audience. Anybody need a 5-minute break?
Probably a good idea.
All right, let's do 5, but we've got an incredible amount of material to go over. So 5 minutes, be back here at 10:25. Okay, it looks like we've got the vast majority of the folks back. So let's go ahead and get started. My name is Bruce Billman. I'm an attorney in Fredericksburg, Virginia. I've been in private practice for 36 years doing nothing but Social Security. As a consequence, I am horrendously depressed. So what I do is I tend to deflect things with humor. And if you hear me say anything that even remotely resembles that, disregard it. This is serious stuff. And whether you guys know it or not, you're in over your head. So you need to pay attention today. Now, sure, I am really, really glad and I'm really, really appreciative that you all are here. I hope you'll stay the course. But these are not easy cases. And if anybody came in here thinking they are, you're wrong. So that's me. Survey, I know we did a little brief one here. Everybody hands up who's done at least 50 Social Security hearings. Okay, 20. 5. Okay, all right. Who all here has a practice that involves medical issues routinely? Okay, that's good. That's about half of us. That'll help. Who all here knows how to spell Social Security? Okay, you're one step ahead of the administrative law judge. I want to mention a couple of things that got mentioned earlier, just so I can kind of check it off my worry list. First of all, there was the question about, is the fraud going to come up at the hearing? You're going to get something called a notice of hearing from the Social Security judge's office, and it's going to be somewhere around 10, 12-page document, and you're going to look at it, and you're going to get halfway down the first page, and your eyes are going to glaze over. Don't do, because it's a form document. It's a merged document. Don't do that. Read every single word on every single page, because they have to give you notice of the issues they will consider. And in fact, it's in bold type on page 2 or 3 or 4, somewhere buried in there, that it says, issues I will consider. So if you don't see something related to fraud or similar fault, and the questions start coming up at the hearing, you need to interject. Your Honor, we weren't given notice that this issue would be heard today. Please bear that in mind. There was a question about getting old medical records, or even identifying who those records would come from, who the doctors used to be, that kind of thing. Now, my understanding is that when you go into this hearing, and Deborah will be talking about this in a few moments, you're going to have an exhibit file in front of you, and the exhibit file is going to ostensibly be the exhibit file that was in front of the judge when the hearing decision was issued granting the benefits. So there are going to be a certain number of those records already in the file that you don't need to worry about figuring out who they are or where they are. But there's going to be another document in there that Deborah's going to show you that's called a disability report, and it's something that's filled out immediately when you file an application for benefits. And of course, one of the things it lists at that point, and this could have been filled out in 2007 or 8 or whenever, is a list of the doctors and their addresses and their phone numbers. And ostensibly, the date I started seeing Dr. Jones and the date I last saw Dr. Jones. So you should look there for other information if you can't rely on your client's memory. In terms of securing records, you're going to have problems getting those records, but Social Security and the administrative law judge do have the power of subpoena. Now, that's illusory at best, but they do have that power. And you need to look at the regulations, and I'm going to tell you where all the regs are in a second, but you need to look at the regulations about the judge's power to subpoena, because there are time limits on when you have to ask for the subpoena. And you have to be able to show that you at least tried to get these and what the problem was. The bottom line is that the administrative law judge will be all too happy to issue the subpoena, but he has absolutely no power to enforce it. So that's not really going to go anywhere. But in terms of what Ned was talking about, or Tom or Rob were talking about, it's an issue that these people have been deprived because of the latches, basically, that they cannot get access to the records they need to kind of, not defend themselves, but put forth their claim. So you can always fall back on requesting a subpoena. Again, it won't work, but it may become one of the issues later on. All right. I didn't ask this question in the survey. Anybody a golfer? Okay, not very many. There's this golfer that's on the PGA Tour. His name is Phil Mickelson, and he's very flamboyant, and he goes for every shot, and you know, he'll be under a tree, under a rock, and he'll still hit it, and you know, just all kinds of stuff like that. And there's a saying on the PGA Tour of, what would Phil do? If you're faced with this enormously difficult shot, what would Phil do? So as you're thinking about these cases and you're going through them, I would urge you to think, what would Eric Kahn do? And then don't do that. Because one of the things that I heard was that Eric Kahn never met his clients. That's awful. These cases are incredibly intimate. You're talking about the most intimate thing in a person's life, their own health, their own body. And if you can't take the time to sit down and meet with these people, you don't belong in this room. So please establish contact with the clients. It will serve you really, really well, because you'll know who you're dealing with. And I'm going to talk to you for a few minutes about technically how you show somebody is disabled and the analysis for that and the steps that Social Security goes through. But here's the bottom line, folks. Somebody is unable to work because of how they feel. Not because they have degenerative disc disease or cardiac disease or diabetic neuropathy. That's not what stops them from working. What stops them from working is how they feel. That's completely subjective. You cannot prove it. You shouldn't even bother to try proving it. You can't force it down Social Security's throat, and you can't make them believe it. But you're going to know. Somebody said something about, yeah, some of these cases are not so good. And they're probably right. But you're going to know who the good ones are. And you're going to know it within 5 minutes. Because this thought is going to cross your mind. I know you can't work, Mr. Martin. And the reason I know you can't work isn't that you have cancer. The reason I know you can't work is because you're not working. period. End of sentence. And I didn't need to know the first thing about your medical records to know that. But I knew who you were within 5 minutes of meeting you. And that's what you're trying to get across to a Social Security judge. Sure, gather up all the medical records. Sure, get all the medical reports. But at the end of the day, that's not what you're trying to do in this hearing. Anybody can gather up pieces of paper. These are about people. And you better have a really good relationship with these people when you take them into that hearing room. Okay, here ends the sermon. We're going to talk about some really simple stuff, but it is important. And the place that I want to start is with the administrative appeal process. Again, this is very simple stuff, but it is important to understand how the system works or doesn't work. First thing I'm going to tell you is that everybody has to go through an administrative part of the claim with the Social Security Administration. And there are 4 levels that people can go through. Now, you really don't care about the first 2 because we're already past that. We're to the 3rd step, which is the Social Security judge. And just by the way, if you want to follow along in your hymnal, that would be on the 2nd page of the Introduction to Social Security Disability Law. There's a flow chart there as to what the process is. First thing to remember, 60 days. Whatever it is you're doing, you got 60 days. Don't blow it. In terms of the process, even though you're past the application and you're past the reconsideration and you're now at the hearing with the judge, it's important to understand what happened at those first 2 stages, because there's evidence from those first 2 stages that is going to be used, dare I say it, against your client. And the way this all works, you have to think about the Social Security Administration as an emergency room, because it's the same deal for the ER as it is for Social Security. Neither place has enough people to do their job correctly. They just don't. That's a fact. And so both have a working business model that's the same, and it's premised on that fact. So when you go to the emergency room, what do? Anybody? Triage. That's what the application and the reconsideration are. They're triage. That's all they are. They are not trying to find everybody who's disabled. They are trying to find the worst of the worst of the worst of the worst and get those. And I'm going to tell you how they do that in a second. But the method that they do it by is your client goes in and applies, and then Social Security, well, I'm an old timer, so I think about, file folders. I don't think about directories and file trees and stuff like that. But they take the folder and they ship it off to these people who are going to make the disability determination. They're called the state agency. You see them there on the flow chart. And I think in Kentucky they're called the Disability Determination Service, maybe, DDS.
Yep.
That's what they're called in Virginia as well. But they're called different things, some of them I can't say, in different states. Here it's DDS. So they send it to the state agency. The state agency then gathers up the medical records and looks through them to see if they can find things that are just so horribly wrong that anybody with half sense and one eye would know that guy's not going to be able to work. And we're going to talk about what they're called, listings, and we're going to talk about those in a second. But that's all they're doing. Give you one example, one that you're all probably familiar with and didn't even know it. That's called statutory blindness. So when it gets to the state agency and they open the file and they see, oh, this guy's trying to say he can't work because he can't see very well. All they're going to do is write the ophthalmologist. They're going to get the vision test. They're going to send it back to the state agency. The state agency is going to look at it. And their triage criteria is 20/200 in the best eye, corrected. Corrected. Best eye. Doesn't matter if you don't even have another eye. So they get that back, they look at it. If it's 20/200 or worse in the best eye, they're going to send you a letter back that says, oh my God, you're in terrible shape, you can't work, here's your check. But if it's 20/195, you're going to get a letter that says, well, you're not in a coma, you can work. And that's all they're trying to accomplish. That's all they're trying to accomplish. But in the meantime, the state agency physicians who have never seen the client, have seen maybe half the records, are filling out these reports that say, and I think this guy can, leap tall buildings in a single bound, and he can stop speeding locomotives, and he's faster than a speeding bullet. He can walk and stand 6 of 8 hours a day. He can lift 50 pounds occasionally, frequently, and 100 pounds occasionally. And that's your client with the amputated foot because of the diabetes. But that's what they're going to say. And the reason I bring this all up is that report is in the file at the point you get to the administrative law judge. And lots of administrative law judges think these reports from the non-examining physicians are really cool stuff, and because these people, they're disability experts, and I'm going to pay a lot of attention to them. And you need to be aware that they're in there. That's what the judges, I guarantee you, it's one of the first 2 or 3 documents that a judge turns to when they're opening a file and starting to think about getting ready for a hearing. And that's their starting point. Yes, sir.
Is that report available to you?
Yes, it's available to everybody, and we're going to have somebody come up here and show you how to get it. The question was, is the report available? It is. Okay, so now you're at the hearing with the administrative law judge, and you go through this hearing, which tons of people are probably going to talk about today, and you lose. Now what? Well, first thing, you have 60 days. You can file an appeal, and the appeal is with what's called the Appeals Council. That's the Social Security Administration's version of their Supreme Court, so to speak. And you'll see in the flow diagram that I've put a little rubber stamp in there, in the box, because that's what they do. They rubber stamp the administrative law judge's decision. But there's a reason for it, and it's a good reason. The reason is that the Appeals Council's job is not to figure out whether your client was disabled. That was the ALJ's job, and they're not going to second guess that. So the Appeals Council is bound by what's called a substantial evidence standard of review, which means, in practical terms, all benefit of any doubt on any question runs to the administrative law judge. If you've got 52 pieces of evidence that says your client is disabled, and you've got 3 pieces of evidence which may or may not include the state agency physician's opinion that says that he's not, and the administrative law judge decides that he's going to weigh in favor of those three pieces of evidence, then your request for review will be denied, because there was substantial evidence to support the administrative law judge's decision. You should never want to be in the position of arguing the facts with the Appeals Council, ever. You want to take the administrative law judge's decision and his findings or her findings of facts, and that's what you're using as a basis for the appeal. So the only other way that you can undo something at the Appeals Council is if the judge is committed an error of law. And that's way beyond the scope of what we're trying to do today. But what I'm trying to tell you is you don't want to go to the appeals council. Absolutely not. The ALJ is the Alamo. That's where you're going to make your stand. If you do end up at the appeals council and you're denied, you have 60 days. You're now done with Social Security. You're done with that. And you now have the right for judicial review in the federal court system. And you start at the United States District Court and the division wherever your client happens to live. The federal judge is also bound by the substantial evidence standard of review. And I'm going to tell you it's all over the board once you get to the federal courts. In the Eastern District of Virginia, you can't win, period. But different federal judges are more proactive than others. And honest to God, I didn't have time to look up how you all's situation here is in the federal district court. I just hope it's better in the Eastern District of Virginia. And again, that's kind of beyond the scope. So I want to make sure that you understand when you leave here, you're aiming at the Social Security hearing with the administrative law judge. That's where you're going to make your stand. And you've got to put in a hell of a lot of effort to make sure that record is pristine if you have to go any further than that. Okay, that's the process. Any questions? All right, next thing we're going to talk about is the type of benefits. This was mentioned a little bit earlier. There are two types of disability benefits under the Social Security Act. The one that, well, one of them is called Social Security Disability. It's also called Disability Insurance Benefits. And in fact, the notices that you get from Social Security, that's what it says at the top. It says Disability Insurance Benefits. And the most important word on that page is insurance. Whether you knew it or not, what you've been doing all of these years is you've been taking out insurance with the Social Security Administration. And the insurance pays off in one of three instances. Either you get old, and that's the one we all think of, and you can retire and it pays off. Or you die and you leave a few kids and a wife or a husband, and it'll pay the survivors until the kids get up to 18 years old. That's survivors' benefits. And then the third insurance you've been taking out all these years is disability insurance. Surprise, surprise. And I can't count the number of people who come in my office and go, I didn't even know this stuff existed. But that's what you've been doing. But the problem with this is that it is insurance, and when you take out insurance, what do you got to do? You got to pay for it. And the way that you go about paying for it isn't even the taxes they take out. It's not that FICA thing. It's just the fact that you are working. And as long as you're working, you're effectively paying the premiums for all of this insurance. Now, I've got stuff in the materials which 20/20 hindsight I never should have put in there. It talks about how you earn quarters of coverage so that you can get this insurance and so on and so forth. Skip it. It's TMI. But you have to realize with disability insurance that when you stop paying for it, that is, you stop working, it goes away. So I was glad to see people who deal with medical issues. I'm assuming some of them are like personal injury lawyers and stuff like that. And occasionally what you run up on in those cases is that the insurance had lapsed and the loss had not occurred while the insurance was still in force. Well, the same concept applies to Social Security. When you stop working and you stop paying the premium and you have a loss after that, what's the insurance company tell you? Anyone? Oh, come on, guys. Not covered. With Social Security disability, the good news is there is a really long grace period. Really long. 5 years. So what you're going to see in some of these files, and maybe a lot of them, but maybe not all of them, is that the insurance lapsed at some stage. Social Security calls that date the date last insured. And if you get nothing else out of this session today, remember the date last insured. It's horrendously important. That's one of the first things you need to know. Is the date last insured gone? You're going to be trying these cases as if you're walking into the hearing room the day before the last hearing took place or the day before Judge Daugherty issued his decision. And what you need to know is, was the DLI, was the person still insured on that date? And it won't be plastered all over the file, and Deborah will show you actually where it is. But it's in there, and it's a big deal, and you'll be able to see it and find it readily. So you may be walking into a hearing where the issue is that the claimant has been disabled since 2006, and the date last insured was December 31st, 2008. And you're sitting here scrambling around getting evidence in 2015. What's the relevance of that? Not much. The date last insured is, you got to know that. And you got to develop all your evidence around that date last insured. So if you see that this person is going to Dr. X and has been going since 2006, go talk to Dr. X and get him to talk about what the condition was prior to December 31st, 2008. That's the initial focus. If the judge believes that the person was disabled before that date, you're still responsible for showing the disability continued, I think. I'm not sure. Anybody, you got any thoughts on that?
I don't think it's...
This is just up through the, okay,
Yeah.
well, that's a good
I
thing.
think it's an onset question mostly.
Okay, so you're not responsible for showing continuing disability after that?
Nope.
Okay, that's a little bit of an oddball for Social Security cases, but it sure saves you a lot of work. That's good. But be aware where that DLI is. If you're insured, then all you got to do is prove that you're disabled, and we're going to talk about that in a minute very quickly. The other disability program is called Supplemental Security Income, or SSI disability. In order to get SSI, there's none of this you have to have worked or you have to have earned quarters of credit or any of that stuff. All you have to do is prove that you're disabled and that you're financially eligible for the SSI. And we're on page, I think, 4. To get SSI. The standard of disability is the same under both programs. For SSI, financial eligibility means you've got less than $2,000 in assets. And what an asset is or isn't is sort of beyond the scope right now. The judge is only going to be concerned with the disability issue. He's not there to say whether they're financially eligible. If he says you're disabled, he'll send it back to the local Social Security office to figure out whether your client is financially eligible. But you can do some screening here. If you're talking to the client and you find out he's got a cigarette boat parked on the river, the SSI is not where you want to be headed with this. Also, they have to have now less than $733 a month in income, but depending on the year that you're trying to show the disability, that amount would be less and less and less. There is I may need to post this to Charles's listserv about what the income limits were for each year. I don't think I put that in the materials. All right, so that's the two kinds of disability. Questions? We're good? Everybody thumbs up? Okay. Anybody awake? All right, lastly, we're going to talk about how to prove disability. And we'll go through this very quickly. The Social Security Administration analyzes each disability claim, SSI or Social Security disability, in the same way. Very mechanical, very mechanical. There's a 5-step sequential evaluation. You need to have that phrase in your head. Plaster it up on your wall. Do something. 5-step sequential evaluation. And it is for Social Security, well, let me back up the bus and say this. Where to find the law? The law you guys care about is found in the federal regulations, the statute, not so much. Tom? Yeah, oh, he's holding up the book. Okay. It is online. 20 CFR section 404 covers the Social Security disability regulations. In particular, the ones that you're really, really interested in reading, and I would challenge you to go home and read these. 20 CFR section 404.1500 et sec. You would do well to read them. They're dry, focus. You really will do well to read them. There are a few that you really, really should pay attention to. One of them is 20 CFR section 1527, which has to do with opinions about treating physicians, and 20 CFR section 1.1529, which has to do with the credibility of subjective testimony.
Bruce?
Yes.
It's 404.
Yeah, I'm sorry. You don't know this. I was up late last night. All right. So here are the 5 steps they go through. Every case is looked at the same way, and you have to look at it through the judge's eyes in this way, because every issue that ever comes up in a Social Security disability case flows out of one of these 5 steps. You have to know these backwards and forwards. They're not difficult. All right. So you're applying for disability. What's the first question out of the box? Are you working? If the answer to that is yes, did you cheat? Did you cheat? If the answer is yes, you lose. We're done. And this is going to be a question, I think, in the cases that you're going to be seeing. Hard to say, because I don't know whether there are going to be questions about what happened after the hearing that was held last or after the favorable decision. You know, some of these people probably got a little desperate and went to work. And that may be floating around in the background somewhere. You need to really ask your clients very closely about work activity since the date they claim they became unable to work, on up to now. You need to have a clear picture of that. The definition of work is just a number. It's, I made X dollars a month gross. And I think, you know, that's in the regulations as well. Currently, right now, just to kind of give you a sense of where it is, I think it's is it 1,100? I think either that or 1090 a month. So if you're making $1,101 a month, you're working. This case is over. Thank you very much. Again, the issue is, were they working on the day before the decision was issued or on the day of the hearing or before? That's what you're mostly looking for. All right, but assuming the person wasn't working, then you move on to the second step. And the second question is, okay, you're not working. Why aren't you working? Are you not working because you're lazy, because you just didn't feel like working, because the sky was blue today, or is there something wrong with you? Because if the answer is, well, there's really not much wrong with me, I just didn't happen to be working, well, that's their way of weeding the case out early. It's a very, very de minimis test. You have to have something wrong with you besides the fact that you're just not working. So if your client is saying, I can't work because I have dandruff, that one's going to get weeded out at the second step. Or because I have a hangnail, that one's going to get weeded out at the second step. But that's all they're trying to do, is find the most minimal of problems. I've included in the materials the legal definition of what this is. The technical term for this step is, do you have a severe impairment? And people hear the word severe and go, oh God, yes. I've got really severe dandruff. That's not what it means. All it means is it's something that affects your ability to work. It limits you in some way, shape, or form. If you don't have a severe impairment, you lose. It's over. Go home. If you do have a severe impairment, you go to the other end of the scale here with the third question. The third question is, well, is this thing so awful that we would just know you couldn't work? And that's this screening criteria that I alluded to a little bit earlier. They call them listings. And if your client has a medical condition that meets the requirements of a listed impairment, then that is presumptively disabling. I've included in the materials examples of listed impairments, and they begin at page 17. I'll just pull out the first one, which actually is on page 18. If your client says, I can't work, I get really short of breath, I have chronic obstructive pulmonary disease or something like that, then the listing requirement or the screening criteria is how much air they can force out of their lungs in 1 second. It's called a forced expiratory volume, or FEV1, at 1 second. And this is the listing on page 18. It's very simple. I am 67 inches tall, and I can't push out more than 1.35 liters of air in 1 second. Mine is 1.27. Well, that meets a listing. And that person is automatically and presumptively disabled. And that's the end of the analysis. You win, you walk out the courtroom. Don't worry about anything else. When I first did this, literally, when I first started doing this, I had a hearing with an administrative law judge in Macon, Georgia. And after the hearing was over, I asked Judge Smith, is there anything you can think of that I could do to make myself a better Social Security lawyer? And his answer was this. It was a very surprising answer as I look back on it, but he was absolutely right. He said to me, read the listings. I thought that was incredibly bizarre. But if you're familiar with the listings and the requirements of the listings, you understand your client's medical problems. And you can talk intelligently about that with the doctors and the judges. I assure you, if you do that and you kind of study it just a little bit, you will be able to, what's the word I'm looking for? Well, you will talk convincingly in front of an administrative law judge if you can talk this lingo with him. And it was actually kind of fun. You know, I got to go to medical school without blood. You sit down with the listings and you hit a word, you don't know what it means, pull down the medical dictionary. Well, I pulled down the medical dictionary, now you Google it. And you find out what it means, and all of a sudden you start to realize this really is the neck bones connected to the shoulder bone. And it's really pretty simple mechanical stuff, and it's pretty wonderful how the human body works, and you'll really, really, really understand it. So read the listings, or some of them, the ones you're going to run into. There are 116 of them. I'm the only guy on the planet who ever counted them. And I can pretty well tell you that I've never used 80 of them. But you'll figure out which ones are most important. Read them, and more importantly, understand them. So if you meet the listings, you win. There's an example in there of one of the mental impairment listings. You're going to find you're using those all the time, and you really need to immerse yourself in those as well. But assuming that you don't meet the listings, and it's sort of unusual to find one where you do, because presumably, the state agency already found all those. No, they didn't. But there are going to be lots that slip through, but not every case is a listing, far from it. I don't know, you got to guess, maybe 10, 15% of the cases you see might be listings, everything else is not. But that's not a disaster. If it doesn't meet a listing, you just move on in these 5 steps on page 6. And now what you're doing is you're trying to figure out if the person is disabled or not. And disability means the inability to do any job 8 hours a day, 5 days a week, 52 weeks a year. That's what it means. I've made this statement a lot. I have never, ever, 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 and you never, ever, ever, ever will have a client who can't work. Ever. The fact that they're in your office means they can work. They can go answer your phone. The question is always, how consistently? From 1 minute to the next, 1 hour to the next, 1 day to the next. That's always the question. And the last 2 steps of the sequential evaluation are designed to try to figure that out. First, the fourth step is, can they do their past work? Past work means anything they did in the last 15 years, leading up to the day of the last decision or the last hearing. If the answer to that is, sure, I can do that, you lose. Why? Because you can work. So you have to understand the demands of the person's past work. You have to understand what that work is, and sometimes that's a really neat trick. People don't remember what they did. But then you have to understand what they did and what it demanded. I had a hearing last week with a gentleman who was a Green Beret for 25 plus years, and his job was to, after he got out of the Green Berets, was to examine the body armor of not so lucky soldiers and figure out what went wrong. And Social Security had been turning him down the whole time. Why? Well, you just sit there at a table and kind of look through this stuff. No, that's not what you do. And job titles are very, very, very misleading. You need to ask them, what does that mean? What did you do? Because that's what you're trying to show them they can't do. So get into the details of that. I've included in the materials a, where did I put it? Oh, there it is. Page 77 is what I call a vocational profile. And I always turn this in before the hearing with the judge. Because what you're trying to do is prepare the judge and prepare yourself for what you think the judge is going to think. So you're going to tell him what the person did. Now, there are forms in the Social Security file that the clients have filled out on their own. And they may be okay, they most likely are not. And so you want to give him a very detailed picture of what the person did. I also include a picture. Judges love pictures. They love to put a face with a name. And then attached to that on page 78 is an extract from the United States Department of Labor. There's a book called The Dictionary of Occupational Titles that you're going to need to become very, 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 very familiar with. And you can see how it describes what she did as it's normally performed out there. And from that, you can then start to talk about why she can't be a certified nurse's assistant. But you have to establish the demands of the job. Assuming you get past that, then the judge has to decide if there's anything else that the person could do. And that's step 5. At that point, the burden of proof is no longer on you, it's on the Social Security Administration to determine whether there's other work out there the person can do. And I am seriously, seriously out of time, but I've got to throw this at you, and I'll keep it to a dull roar. They have 2 ways of doing that. And the main way that they want to do it is they have a list, a table that combines the person's age, the person's education, the person's skill level from their past work, and the person's what they call physical functional capacity or residual functional capacity. And it's either this person is limited to sedentary work, desk jobs, or light work, selling Dockers at Penny's, or medium work, a certified nurse's assistant. And there's a table depending on which of those you are, sedentary, light, or medium. If you turn to page 25 of the materials, you'll see the table for people who are limited to sedentary work. And it's really cool. They just punch in all these figures and out comes an answer. You put in your coin, pull the handle, and out comes an answer. So if you're of advanced age, which for them means 55 to 59, and you have a limited or less education, for them that means less than high school, and your past work is unskilled, and you're limited to sedentary work, poof, there's your answer. You're disabled. And you've got to be really familiar with these things. These are called grids or grid rules. And you need to go through each and every one of these, and I've published each and every one of them for you. And you need to figure out which permutations and combinations get you where you want to go, and that's your goal for the hearing. So that's one way they can do it. There are, again, I'm the only guy on the planet who counted them, and I've already forgotten the number. There are 82 scenarios there amongst those tables. 65 of them lead to the decision not disabled. Only 17 of them lead to the decision you're disabled. And so you need to know the differences. You need to know what's good and what's not. So if you're stuck in a rule that seems to say that you can't win here, that they're going to find you're not disabled, then you have to figure out a way to get out from under that rule. And the way you get out from under it is by telling the judge, or establishing by evidence, that this person has things that go beyond sitting, standing, walking, and lifting. Because that's the only things that define which table you're in. Sitting, standing, walking, and lifting. So if you've got something beyond that, something that's can't be included in this rule, then you're out of the rule. The rule doesn't count. The rule doesn't apply. So let's say you have chronic obstructive pulmonary disease and you can't be in an environment that's hot or cold or with dust or fumes. Well, where's that accounted for in this rule, Judge? It's not. So the rule doesn't apply. Those are what were referred to earlier as the non-exertional limitations. You have to be able to establish non-exertional limitations. If you do, you're out from under the rule. And at that point, the judge has to call in a live vocational expert and do this on a case-by-case, limitation-by-limitation basis. It can get a little tedious in the hearing. And there are gobs and gobs and gobs and gobs of non-exertional limitations. And I've tried to suggest to you in the materials what some, maybe even most of those are. But you need to develop those fully and be able to have the client explain and the doctor explain how those also impact the ability to work. I'm schizophrenic. Don't put me in a job where I have to deal with the public. Well, that's not in this rule. And yet that may be a big one. What if the person can't be exposed to the public at all? So you ask the vocational expert. Mr. Vocational Expert, assume this individual is limited to medium work. They can do construction labor. They're, physically they're good to go, but they can't be exposed to the public at all. Can you think of another job this person could do if that's the problem? And they'll probably come up with some. So you have to find more problems and start ticking these things off. Okay, that's how you analyze a Social Security disability claim and what disability is. Any questions? TMI. All right, folks, you've been very, very attentive. But these people are really going to tell you what's what here.
Hi, I'm Deborah Schifrin. I'm from Akron, Ohio, and I'm hoping this computer has internet. I don't know how to unlock it. Do you know how to unlock it? Is there a password?
Right on the monitor.
Ah. That's cheating. Oh, caps lock's on, that's why.
Okay.
Right, caps lock. Okay. hoping to do, now that you've heard about all these different areas, I figured I'd show you your new best friend while you're doing these cases. And that's going to be SSA.gov. If it lets me do it. It's much easier if I was able to use my laptop, which I did bring. And be careful that you don't type ASS.gov because I've heard that takes you to a totally different type of site. At one point they actually changed it to socialsecurity.gov for that reason. What you want to do when you want to search, like listing of impairments, and then what I just do is make them a favorite. I can type today. Hello? This is not working for some. Trying to get this to work, and of course. All right, there it is. Just first time you go, this is the adults. Now, you're going to notice that some of the listings are new, and that's going to pose an issue because of the old nature of these cases. So one of the things that I have, which is a presentation I'm actually doing in Denver on, it's called POMS. And if you go to, it shows you where to go to get, where are the POMS and how to find them. But the most important thing, and I'm going to show you that, is the obsolete listings are on the POMS. So you're going to want to go back and look at the types of body parts that your clients have and look at the old listings. Because these cases go back a number of years. And now that the camera is gone, I'm actually going to show you now. We have someone who moved to Northeast Ohio, who I'm representing currently, who was a con case, and she did give me permission to share with you her file. So this is not how the disc looks. This is actually because I download from the website. Which you're going to learn about. I think, Bruce, you're going to talk to them about the electronic records and how to. We're going to try and teaching you how to register. But if not, if you do receive the disc is going to have a password, and I'm trying to. It's been so long since I've used a disc. I believe it's the first 4 letters of the client's first name and the last 4 digits of their social security number. Does anyone know? Is that correct?
Yeah.
Is it? Okay, thank you. Shows how because I just download everything. And theoretically, you are the only one when you do get certified who is allowed to download the file. This is her file that is the case. What was interesting to me, and I bookmarked it to show you. So one of the things you're going to want to do is go through exhibit by exhibit and actually know the file. And I do bookmarks in Adobe. This is a reader, but I have full Adobe and I do my bookmarks because you can't do it in the reader. And you'll see I have all kinds of abbreviations here, but I want to show you, this is the actual decision. Let's see if I can make it smaller. So you can see the whole page if you can't. Is it showing up there? If you can see, want to show you here. Is it going to do page by page? Where did that go? Trying to, I'll just scroll. But you can see this was the Dougherty. You see the date of the decision. It's February 2nd, 2011. The other key things you're going to want to know here is, first of all, this is one that wasn't on the record. So there was no hearing. And that's going to be important for when we're talking about whether they had an opportunity to testify previously. This gives you a lot of the information you're going to want to have. The date last insured tells me what the severe impairments were that the judge found, and gives me the RFC that he came up with, including, I believe in here, I don't think, most of them do refer back to the judge's, to the medical evidence, and he did not. And you see that, it's just very short, sweet, brief, and saying that she's been disabled since July 31, 2007. Now, what's important to know here is that for reasons when you're trying to go back, and for purposes of overpayment issues later on, and that's why this is important, although she was found disabled as of July 31, 2007, For practical reasons, the earliest date she would have received benefits is 1 year prior to the application date. So in this case, her application was filed on April 12, 2010. That means her benefits did not begin until April 2009. If it's SSI, the benefits begin the month after the date of application. And those are just important dates for you to have so you know what period of time you're actually going to be dealing with. And for this case, it's important because she would have turned 50 prior to April of 09. And you just heard Bruce talk about the grids. Now, some of the letters you've all heard about, and we were talking about, here is the actual AC remand order that went back. This is from July 1st, telling her that the Inspector General has sent your case to us, and we're sending it back because you had evidence from one of these doctors. So you want to look through and see what it's going to say in the remand order. And it says disregard any evidence from one of the medical providers. Now what's kind of interesting to me, and the reason why I have both here, is, and you'll see that's, well, I'm going to go back to that in a second. There is no, if I go through the list of medical evidence, which is the F section, there is no evidence from Dr. Hess, which was the doctor who supposedly, and that's why I have the case file as well. The problem is, unless you become entitled to access the files online, you are not going to have access to the case file. Online is the only place you can have the case file. Because this is the unpulled case that has, including everything that are non-exhibited items, and I'm going through because I found them. Here's the letter. You see there's no exhibit number on this, and this was the letter to her on May 18th telling her that she was suspended from benefits. And what's interesting is that's 8 days after OIG said that it was okay to suspend these people. So they worked very quickly, and to be honest, Social Security never works that quickly. When you need them to, they don't. The other, so when I went through this, and I'm pulling it down, the first thing here, here's my doctor, that's the doctor. You see it's not exhibited as an exhibit. This is the medical records from Dr. here that they're disregarding. But I have to tell you, this was a really, I don't know who prepared it. I don't know if he ever examined her. I can't answer that, and I will talk to her about this because I thought it would be in the file and it wasn't, and then just got the case file after my hearing yesterday before I left, is it goes through all the medical records. It does a really nice detailed list of all her problems. But it's not exhibited, it's not considered, and I have to totally disregard it. But at least it gives you a summary of what was there at the time that he evaluated. And then I go through, and I'm trying to minimize this, and that's why I'm saying is I go through and you see, I mark everything by page, and this one I probably did more detailed than any others, but you have to know the record, right side, back side, forwards. In this case, there's MRIs, and there's a lot of interesting evidence that would probably have limited her to sedentary work. She probably could not have stood and walked 6 out of 8 hours a day. And depending upon her past work, she would have been entitled to benefits as of her 50th birthday, which again, the reason why that's important is for purposes of the overpayment. It's going to be a later onset date. Yes?
I'm sorry, if we apparently are dealing with slow learners. But I'm in this world, we're told we've got 6 assignments. We don't know how to access cases. We don't know how to get records. We don't know how to get people.
Okay, that's what I'm going to tell you, explain this, but I wanted to show this while the cameraman was out of here. We asked him, because she gave me permission to share this with you, but not with the public. So I had to be careful.
Everybody else knows, we can talk to you after session.
No, I will explain very, That's why I said this is going to be that disc that you receive from your client with the password. The password will be your client, or when you become your client should have, that was sent to them with this remand order, a disc of their evidence. And that disc you put into your computer, as long as you have Adobe Reader, you have to put in the password that says the first 4 letters of their first name and the last 4 digits of their social security number. It is then going to give you a list by A, B, D, E, and F exhibits. And you have to click on each of those sections, file folders, and then it will give you each of the exhibits by number. I think that's his, or is it just do 1A, 1B, 1D?
You got the exhibit list to show us?
Yeah. That's an exhibit list. This has been converted by a program that we have, because when you do enough of these, you need to have a program that converts it from PDF to this type of format so it's easier to access, rather than
Somebody
each.
dropped the lights, you can't see that screen.
Okay.
The lights.
Can we, you know where it is?
Right here. Should be right there.
And I apologize for confusing, but I figured this was an quick little just showing you this, and then we'll go into other issues.
You're showing us the case file, what we...
No, this is the exhibit file.
The exhibit file, but it's not the ERE thing. This is on the CD.
No, well,
No?
yes, theoretically, yes. It will just not be in this format. The CD will be, each exhibit will be a separate file, and you have to open each one. But it will also give you the table of contents, so you can look at the table of contents also on the CD. Like I said, it's been years since I've looked at a CD, because we do download the files, and we're going to have instructions, if you don't already, of how to go to your local hearing office to be certified to download and get it signed. But if not, when you receive the CD, you open it, you'll have a list of the exhibits, a table of contents, and also then you'll have each exhibit listed separately. I'm not sure if they have different folders for A, B, D, E, and F. There are no C exhibits. Or if it's 1A, 1B, 1D, 1E, 1F, and it just keeps going through. And I apologize, like I said, it's been so long since I've looked at a disc, I can't answer that. But all of this will be there, and there's also, like I said, the table of contents. So the table of contents will tell you, but it's only going to be marked exhibits. And in these cases, the problem is they have not marked the medical records that they're disregarding. So the judge will have access to those. You will not unless you become certified to access these files online.
Give them the short version of how to do that.
The short version is the easiest thing really is going to be doing is, I think we're in the process, I thought you were talking. I know that used to be that you could call the your local hearing office, and it doesn't have to be where the client lives, it's just the hearing office that's closer to wherever you practice. And you can look and see where that is. There's on Social Security's website. There's, yes,
I'll put a step-by-step on this.
okay. Bruce will put, how to do it, but there is a way to go and learn how to, and then they give you a username and a password, and you go into ARS and log in, and you can then download, you request the file, or you can look at the file online, and they send you then a link to the file that can be downloaded as a PDF. Yes?
Okay, so the disk will have a table of contents.
Yes.
So what you have up here is a table of contents that you've generated from an Adobe.
From something that we downloaded from Social Security's website.
Would the file have Dr. Kerr's report on the CD?
No,
No.
it probably will not, because it's not a marked exhibit, and that's what we found out when I looked at this yesterday. Yes,
Now, you said the doctor's report is disregarded, correct?
correct. I
But
should say
the
with this,
medical reports, are they also disregarded?
from the doctor who did, the 4 doctors that are in the letter from Social Security, those 4 doctors, their reports are being disregarded. The question is what exhibit is disregarded, and it's the 4 doctors that Social Security has deemed were, for a better term, cahoots.
But the medical reports that they relied on, hospitals, whatever, are those included or are those automatically disregarded?
Those should be, questions whether the other medical reports are included. I will tell you from what is here, and it looks like everything that was referred to by Dr. Hess in that 5-page report is here in the file.
It's going to be a mixed bag.
But it's going to be mixed, and I'm saying, so I have evidence here going back to February of '07.
Some files won't have much in them.
Okay. It depends what evidence was submitted to Social Security at the time. If the evidence was submitted to Social Security, except for the reports from these 4 questionable doctors, it should be in the file. Because I saw some other questions. Yes?
I probably missed this, but you mentioned having to be certified to get access to the file and then having the data access. How do you become certified?
That's what Bruce Billman just said. He will put on the listserv that has been set up that's called the MESS.
Yes.
It's a Yahoo group called the MESS. THEMESS. And if you go to, you can send a request to be on the listserv, and that's where he'll post those instructions.
But basically, you contact your local Social Security office.
No, hearing office.
Hearing office.
You have to,
Right.
and let's
There's
do,
a local hearing office here in Lexington.
I'm trying to get back to Internet Explorer. Let me go to this one. If you go to ssa.gov, it's been a long time since I've looked these things up because I have them all bookmarked. But it's hearing office. You can search everything here. And that's what I'm saying, this is your new best friend. You hear, so we're region 5. No, you're not, I'm sorry. You're right, I apologize. The 6th Circuit is split between region 5 and region 6. So if you're in Ohio and Michigan, we're region 5. If you're in Kentucky and Tennessee, you're region 6. So if you just go here, is this correct? No, it's not region 6. I think it's region 4? Yeah, Paducah would be. There's a list of the hearing offices in region 4.
Lexington's up there.
So you see Lexington, Paducah, what else is in Kentucky? Louisville's there. But those are the hearing offices, so you can find whichever one would be closest to you. Yes, sir.
So you automatically, as Tom was saying, want to preserve an objection that they're excluding the 4 doctors to begin with? So you have something to appeal, or you just take it off the chin and say, okay, no problem?
Yeah, I think I can answer that.
Why don't you come up here then and answer? The question was whether the 4 doctors are those reports are automatically excluded. I will tell you, it appears that Social Security is automatically excluding them from files already.
Yeah, but if you're preserving it for appeal,
That's why,
you haven't got
yeah.
a chance to look at it, it's a new process.
You know, the answer to your question may be whatever Judge Thapar says. Let me try to recall and summarize the argument. It was a typical Judge Thapar phone conference. Even though it was a plaintiff's motion, he immediately started cross-examining the SSA lawyer and says, let me see if I understand this. You're wanting to subject these people to hearings with unchallengeable evidence, i.e., we basically put a 0 on each doctor. It's kind of like in a criminal case, Tom. The evidence is suppressed. Our argument, that's a violation of procedural due process, whatever you want to call it, that's not a fair hearing. For the first 10 minutes of the phone call, I thought we were in pretty good shape. Thapar was saying that at these hearings, taking it back, the SSA conceded under grilling by Judge Thapar that we can't go anywhere near the 4 doctors. It's almost like the evidence is suppressed. Now, I don't know what his final ruling will be. What he may do, and this will be a victory but not a good one, is he may say you can have these hearings, but you can't have unchallengeable evidence. Unsuppressing evidence is the best way to explain it. On the other hand, we could lose, and the legal reasoning why we could lose just has to do with the fact that Thapar may say he has no jurisdiction. You cannot, it's like these EPA cases, you can't go to federal court and tell an administrative agency how to run their business. Basically, the federal judges don't want anybody who's mad at an administrative agency running the federal court saying you're violating their own rules. There's some really bad law on that, and if we lose, it'll be because of that bad law. The case is Illinois Council. And he actually made us write a supplemental brief on Illinois Council. But in terms of, the question is, can we say the word Dr. Huffnagel? I don't know. Basically, what I understood the SSA to be saying during the phone conference is it's basically, all that evidence is unchallengeable, it's like suppressed.
The other issue is, just so you know, is the other problem with these doctors' reports is when they testified before Congress, each and every one, except for the one who was deceased at the time, testified that they had lost their license.
It's tainted.
So that's the whole issue. So even if the evidence is allowed in the file, it's not a licensed physician, so therefore it's going to hold minimal weight.
You may want to use it for,
Tom, go back up and talk about the, your bifurcation.
just real quick. Now, the question is, to what extent should you use or introduce or rely on any of the 4 doctors' reports? You want to generally stay away from those. But there may be cases, in this particular case, for example, I don't know everything, but if the witness says the doctor did a full exam, that looked like a pretty detailed report. And you don't want to rely on it directly, but it may be a way to say that it is consistent with the other evidence of record. The physical examination may be consistent with other evidence of record. There may be findings, so there may be pieces of it. You might want to offer it by a vow, something like that, to where you stick it in and just say, we need to not ignore it because it's part of the record. I'm not relying on it directly. Something like that. I think it's going to be a case by case, but I think generally you don't want to rely on that. If that's all you got problems.
Well, my concern is not so much, it's just a simple question of how do you preserve the objection to the our rules or if the bar.
Yeah, I think you can offer it by a vow.
Well, what I would...
Yeah,
What I would actually do is send a letter requesting to the judge that this exhibit be moved from the case file to the exhibit file and be exhibited as a document in the claimant's file. And that way, if he refuses, you've preserved the right for appeal. And make sure your letter, however, is in the file. And that's something you know is everything is electronic, so when you do become the representative, you need to request a barcode to either fax or
They'll send it to you.
they'll send you a barcode, or you need to ask for it so you can fax in all these requests, and you need to say that it's not a medical evidence, it's a letter to request. So they will send you separate barcodes for everything. Yes, ma'am.
So the doctor's reports that were suppressed, whatever, are in the case file, not on the exhibit list?
Correct.
Both of which are online?
Correct.
So after the fact, the Social Security, whatever, took out evidence.
They also took out, they also,
Okay, that's, no.
They took it out.
they didn't exhibit it.
Set
They
aside the decision.
and they
based
set,
on
and they,
that.
right, they set aside the decision and didn't exhibit it. And the other issue they did is, there was a letter,
The evidence was suspect, so you have to take the
Right.
evidence to find.
They said it was paid by fraud.
and they also did not include this due process notice.
But they removed it, that's just crazy.
That's right, no, it's gone.
Okay.
It's in the case, right, I'm shocked that it was in the case file. So they did keep it, they didn't burn it, destroy it, whatever. It's there, it's just not exhibited. And that's the issue, is when you receive the exhibit file or the disc, it's not going to be there. Now, the other, just briefly, and then I know we have lunch, and then we'll go into this again more, we're going to answer questions during lunch, is when Bruce was talking about the hearing, the earnings, the knowing about the date last insured. This form, which was run on, doesn't say, but I will tell you that it had to be run recently because it goes up to 2015.
You show them that last insurance.
That's what I'm showing them right here. Up here, it says, if you see, it says, if this points to it, DLI, can't highlight it, just highlight it. It says disability DLI 1212. That means
That last insurance.
that's the date last insured, that's the date that the insurance ran out. So in order for her to receive her disability, we have to prove she was disabled by December 31, 2012.
On or before.
On or before, like I said.
Deborah,
Yes.
On the front, on your table of contents, you also, it says, date last insured. Is that something your program puts in, or what is it?
It is, I don't believe it's on the disc.
Okay.
Does anyone here use discs? Do you? Yeah, I'm looking around. They've tried getting everyone. I don't know if it's on the if it's on the table of contents on the disc, and I apologize for not knowing that.
But so you have.
It's on the web. If you do get access to the website and the appointed representative suite of services, ARS, then it is there at the top of it. It's just, I will tell you, 80% of the time, the DLI that's here, the last insured date, is incorrect. I always refer back to, and just really briefly, and then we're going to go to lunch because I think it's here, is when you go through the sections that are show you is A is the payment documents decision, is what they call it. It's actually where the ALJ decision is going to be, in this case, the appeals council order, and also any evaluation by the state agency that was done at the initial or reconsideration level. So this is one that was done in August 30th of 2010. And I'm just show you, and I think, Charles, you have it in your materials but this shows you the allegation of impairments, then they have the medical evidence received, I just already bookmarked them, the listings of impairments and severity, whether they're severe or non-severe. This is the residual functional capacity they found, the state agency, and I never pay attention to that, but you have to in these cases. Because I can close my eyes and based on someone's age, I can guess what the RFC will be. And the list of that's the past job that they had for an optician. That's what I'm saying with Social Security considered to be her past work at the time of the initial. So the A cases are going to be the decisions. B is just all kinds of notices. Although in these, and usually I don't read the B section because it's just the notice of reconsideration, notice of initial denial. But in this case, it has, and there's your barcode, you see that, the notice of the appeals council action, which you're going to want to read because that's going to tell why these cases have been sent back. And there's the key. They're saying that there was fraud or similar. We must determine your case if there's reason to believe that fraud or similar fault was involved in the application for benefits. So that's basically what they're saying.
Is the notice section when we're going to find out if we've got your date scheduled?
Yes. If the question was about the notice section, yes. In the B section will be where if there's a hearing date notice, that will be there as well as the names and resumes of the experts. So you'll be able to see who they are and you'll be able to pose questions on the listserv asking other attorneys who these VEs and MEs are, because 90% of the time, and I don't know if it's here in Kentucky, but at least in Ohio, I have VEs testifying from all over the country by phone. So this is, here's the request for hearing. This is the notice from St. Louis. This person did object to her video hearing. I was very proud, before she even came to my office. So she will not have a video hearing, which I'm very happy about. I will talk about those later, but I will tell you. D is going to be your application. So there's your application for disability, which tells you the date. It gives you then the date she claims she was disabled, as well as the birth date, which is important for a lot of these cases. There's the application for SSI, which means that this is both a case for both disability and SSI. So if she's found disabled after December 31, 2012, she's protected. She can also receive SSI, although it's less per month. And this is what I said. E is going to be the work. Usually it's work and other disability. So here's the form that she filled out back in April of 2010 with the work she did. That's her work history. And here it tells you what she was paid, how many hours she stood. And the reason why is you might have to remind these people, because they filled these forms out 5 or 6 years ago or maybe longer. I know I couldn't remember what I said 5 or 6 years ago. So you're going to want to go through this and see, and it gives you an idea of what they did for each of their jobs. And then the F section, as I said, is going to be all the medical evidence. And now I'm going to say, let's go to lunch, and then we'll do more substantive, but we're also going to be around to answer questions during lunch.
Yeah, I'm going to talk about that real quick. We're going to get started again, and we're going to turn it over to Charles Hall momentarily. I just wanted to mention a couple of quick things before it got too late in the day. The referral process through AppleRed. Mary Going, who is our pro bono coordinator, is going to be doing the referrals. So Mary Going is the one you will hear from, presumably by email. We will send you an email with a case referral, and Mary asks that you respond to let us know that you've taken the case and that you're accepting the case. And then when Mary is notified of that, she sends some information to the client, and you guys go from there. If you have questions, feel free to contact Mary or me at any time at AppleRed, by email, by phone. Our information, my number is, I can't even remember my number. I'm new to AppleRed. It's on the website, the AppleRed website, and my email is robertj@ardfky.org.
Are you 3876?
Yes. 606
886
886-3876, extension 1247. Thank you, Tom. So the referral process should be pretty simple. You can make contact with the clients then and do what you need to do. I want to mention that if you need something done locally, you can contact us. I don't want to sit here and guarantee we can do everything that you need, because quite frankly, we're overwhelmed. But if you need something done in town, let us know and we will see what we can do to help you with that. We also have space if you would like to come. Tom mentioned he has space. We have space as well. And he's not in the room right now. Steve Sanders of the Appalachian Citizens Law Center mentioned that they have space as well in Whitesburg, if that would be useful to anyone. We also have video conferencing equipment at AppleRed in our Prestonsburg office. If you have access to video conference equipment and you want a video conference with a client, be able to see them and talk to them by video conference, we can do that at the AppleRed office as well. So keep those things in mind. If you have questions about anything that we might be able to help you with, contact us, let us know. Like I said, I can't guarantee we're going to be able to do everything, but we will certainly try to help as much as we can. Barbara, was there anything else you wanted to say?
About the lister.
Oh, I think Charles is going to talk about it. The listserv is going to be a very important way to communicate with these experts and also with each other to keep everybody up to date on what's going on. So Charles will talk about that.
Well, I mentioned your space in other offices.
Oh yeah, we have offices in Hazard, Richmond, Somerset, and Barberville, in addition to Prestonsburg. So if any of those places you would need some space, AppleRed could accommodate you. So contact me first and I'll get with the local office and we'll get that arranged for you. Any questions about referrals or any of that stuff? And I think I was standing too far to the right. All right, if not, we will move along then to Charles Hall. Let me just get this situated.
Okay, I'm going to sit down to speak. I've got a combination of medically determinable impairments, which limit me to sedentary work, which some of you know is Social Security jargon. That's literally the case for me, and if I were a claimant and could not do past relevant work, I'd easily be approved. My motto in the law practice is KISS, keep it simple, stupid. And that's my goal here today in talking with you. There are 3 points that I want to get across to you more than anything else. The first is I want to get all of you on the listserv. The second is I want you all to understand the procedural status of these cases. When you say procedural, people's eyes start glazing over, but unfortunately it's the essence of these cases and determines to a large extent what you're going to do. And flowing from that is my third point. Get the clients to file new claims. And I'm going to explain to you why this is so crucially important.
Okay, to get you on the listserv, how many are already on the listserv? Okay, we got one. How many of you can send and receive email on your smartphones? Okay, almost all or almost all of you. Okay, we're going to get you signed up right now. So get your cell phones out. It's an unusual thing for a speaker to say, but get them out and get up your email and prepare to send an email to THEMESS, that's one word, THEMESS.
Spell that again.
Case sensitive.
Not case, THEMESS, lowercase, THEMESS. That's what the listserv is called, THEMESS. I was going to call it the cluster something, but I didn't think that would be a good idea. Because unfortunately this is a messy situation. THEMESS-subscribe and Yahoo Groups, that's one word, YAHOO, THEMESS-subscribe at Yahoo Groups, one word, YAHOO.com. Everybody got that? No? What? I'll go through it again. THEMESS, one word, THEMESS, subscribe at Yahoo Groups, one word, YAHOOGROUPS.com. Okay, has everybody got that in? Okay, hit the send button. You don't need to have anything in the body or of the email. You will get back an email from Yahoo Groups asking you, do you really want this? And you then need to, there's a link and you click on that, or I think you can just hit reply and then you'll be on the group. Okay, we'll come back to this in a second. Once I have you on the listserv, I'm going to send you my materials. My materials, unfortunately, for whatever reason, did not reproduce. You can barely read them or can't read them. I'm going to send you the PDF through the list server. Okay? Any of you getting back reply emails yet? Okay, some have gotten back. The others will get back shortly. Just reply to those and you're on the list server. Okay, procedural status. Ordinarily, let's say you have a case with Social Security and the ALJ turns down the claimant and you appeal that and the appeals counselor remands it or the U.S. District Court remands it and you have a new hearing. What is the issue? The issue is whether or not your claimant was disabled at any point up to the date of that new decision. Because this is the law. The Social Security Act in particular, it's, we get to the section here, 402J something or other. J2, I think, requires that Social Security considers it all the way up to the date of the decision. Social Security in these cases, however, is said the only issue is whether the claimant was disabled up to the date of the prior ALJ decision that put the claimant on benefits. How can that be? That decision has been vacated. It's like it's no longer there. It's like we're back where we were then, so why isn't the issue whether the claimant is disabled all the way up to now? Well, legally, I can't give you any reason, any justification. I think Social Security is completely out of bounds on this. I can't even fashion in my mind any argument they can provide to a court as to sustain this. But the ALJs don't have any ability to avoid this. That's what they're going to be dealing with. The ALJs are going to have trouble coping with this. They're not going to understand this. We've had, just this morning, you've had speakers who are hazy on this, and I can't blame them. It's a ridiculous situation. Why does Social Security do this? I think because we're dealing with a lengthy time period after the prior ALJ decision, and they don't want to be forced to do medical development themselves for this time period. They wanted to simplify this, and they basically thought, this is in a remote area of Kentucky and West Virginia. these people don't have access to legal help, we can screw over them and nothing's going to happen. You know, they're just a bunch of hillbillies or whatever, who the hell cares, and they had hired a fraudulent attorney or whatever. No, these people have rights. They're real people with real problems, and some of them already have committed suicide. Unfortunately, there may be more in the future. This is a serious business, and they deserve more serious attention than they're getting. Okay, has everybody gotten back the response on the email to subscribe? Everybody clicked the link or whatever, so they're now on board, officially on board? Because I'm going to send you my materials through the listserv.
I didn't get through, I'm sorry, can you say the address again real slowly?
Okay, The Mess, one word.
Like the letter D, M, E?
No, The, T-H-E. T-H-E-M-E-S-S hyphen subscribe at Yahoo, Y-A-H-O-O, G-R-O-U-P-S .com. The Mess, T-H-E-M-E-S-S hyphen subscribe at Yahoo Groups, one word, Y-A-H-O-O, Groups.com. Send that email off with nothing in the, nothing else is needed, and you will get a response from Yahoo Groups, and then you will then hit the button to say that you want. Okay, now since most of you have done this, I think by now, I'm going to send my materials out, and hopefully you will be receiving them shortly, and you can follow along. You can download them on your smartphone, or better yet, an iPad or something such. Okay. The procedural status is nothing that the ALJs can mess with. They're limited, we're limited, they're going to chafe under this. We and our clients are chafing under it. The logical, what this ends up is the claimant has an unadjudicated period after the time that they were previously put on benefits. And that may be a very lengthy unadjudicated period, 5, 6, 7, 8 years. As time goes on, claimants get older. Age makes an enormous difference in Social Security disability determination. It's very difficult to prove disability for claimants under the age of 50. It is moderately difficult for claimants between age 50 and 54, but it's doable. Claimants 55 and over have a relatively easy time of being approved. Claimants are going to move from one category to another over this time period. And their cases will tend to get stronger over time. They will also have more medical evidence. They will have more medical evidence because before they had their hearing, a lot of them had limited access to medical care because we did not have CHI care, whatever you're calling it here at the time, the Affordable Care Act. And this is a rural area. There were probably little, if any, thing in the way of free clinics. So they had limited access to medical care. Once they got on Social Security disability benefits, they started to have access and they started to go to doctors a whole lot more. So the evidence after the time they were previously put on benefits is likely to be far stronger than the evidence before. But this is being excluded. This time period is being excluded. Very frustrating. I think it's going to ultimately result in all these cases that are being denied. They're going to be remanded somewhere down the road, but we don't want to get remands. We want to get them approved now because we don't want people committing suicide. We don't want them being desperate. We don't want them being homeless. We're trying to prevent, many tragedies here by keeping these people on benefits, if at all possible, or getting them back on. Okay. The filing new claim business is to try to get them adjudication of their disability status after the time of the prior decision. The odds are with new claims that probably a third to a half will be put on benefits on a new claim within 6 months. That would be my estimate. Probably they stand at least as good a chance of being approved, around as good a chance of being approved at the initial level on a new claim as they do on the hearings they're about to have. So, you know, if your client's chances of being approved at the hearing you're going to be representing them on, or let's say 50%, if they add a new claim to the process, you can probably raise that to 75% or more, would be my estimate. So the new claim is vitally important. You should tell everyone, if you do nothing else, tell them to file a new claim. Tell them, I can explain it to you, but just believe me when I tell you, you got to file a new claim. The local field offices in this area have been told they are allowed to file a new claim. For claimants who may have moved away, if they moved to Ohio or, you know, North Carolina or Virginia or Illinois or wherever, they may have trouble with their local field office, not wanting to take a claim, but apparently there's been a directive to the field offices. I haven't even seen a POMS issuance. Somebody told me there was one. POMS is Social Security's internal manual. Okay, so now, given this, here it is. It's 42 USC section 402J2 is the one that provides that a claim is supposed to be valid up to the point there's a final decision. Since the prior decision in this case has been vacated, there is no final decision, so we're back to stage one. Claim is still open. I see no way around that. In the materials, once you get access to them, it's the POMS issuance on this. No point going through it. Okay, the other thing that Social Security has tried to do to make it simpler on itself is to avoid the claimant getting any right to have an evidentiary hearing on the question of whether there was fraud or similar fault, or whether these prior questionable opinions, letters, examination reports procured by Eric Kahn should be considered an evidence. Why did they do this? I think because they're going to have a real hard time proving fraud or similar fault. So there's a reason Social Security or the U.S. Attorney has been unwilling so far to prosecute Eric Kahn for fraud. I remember almost nothing about my first year law school course in criminal law. I do recall being told that fraud is awfully difficult to prove. Any of you remember that, hearing that at some point along the way? Some of you have been involved in criminal law and know that fraud is very difficult to prove. What do you have to prove? You have to prove that the defendant intended to deceive, that the defendant did deceive, and that the deception caused harm. Okay, was Social Security really deceived? You've heard the saying, okay, fool me once, shame on you. Fool me twice, shame on me. What is it, fool me 1,470 times? What kind of idiot ALJ didn't realize these reports were questionable? Was anybody really being deceived? Did the deception cause harm? Was this the basis of the decision? Well, it may well be. If you look at, I haven't seen many, if any, of these decisions in Kahn's cases, but the ALJ may have relied heavily upon these reports. But you know, the other points are very difficult for Social Security to prove. Was anybody really deceived by this? There's also the question of, is this any different than what Social Security routinely does itself? You've seen some of the access to the files in these cases. One thing you'll see in every one of them is an opinion from a state agency physician. These are physicians on the staff at Kentucky or West Virginia DDS, Disability Determination Services, about what the claimant can and can't do. An RFC statement, residual functional incapacity. You'll see these in every file, and you will see that these were relied upon completely at the initial and reconsideration levels, the levels before the ALJ. these physicians never examine the claimant. They never meet the claimant, they never talk with the claimant. These physicians are heavily influenced by RFC guidelines that Social Security does not acknowledge exist, but which we know do exist. So Khan's clients, at least apparently, were seen by somebody. Khan is telling the physician what is needed, but Social Security is telling these physicians what's needed to deny the claim, and they never even see the claimant. Is it any different? Social Security requires ALJs to explain what weight they give to the DDS physician opinions reports. There's a ruling on this. It's a real problem area for them. I think the problem proving, was anybody really deceived, and is this any different than what Social Security itself is doing, is just a real problem for them. But you know, you can't do anything with that at the hearing. That's the problem. This is off the table. They're trying to take this whole issue of fraud and civil fault off the table, because if they have to have hearings on this, a lot of ALJs are going to say there was not fraud or similar fault. This is Social Security's weakest point, these two weakest points, at least in my opinion, that they're trying to avoid an evidentiary hearing on fraud or similar fault, trying to avoid the ALJ making any determination about whether this evidence should be considered, and they're refusing to allow the claimant to prove disability at some point after the date of that last ALJ decision. These are ones that, regardless of what happens on the motion for preliminary injunction, if in any of these cases, and probably a lot will end up in federal court, they're all going to get remanded. Okay, let me get on to start talking about medical evidence and what to obtain. And a lot of this follows logically from the procedural status that you're only concerned primarily with the time period up to the point that the ALJ previously approved the decision, the claimant, which may have been 5, 6, 7, 8 years ago. Okay, Khan probably did little or no medical development. Khan was looking, I mean, I've never met the guy, but to me, he sounds like a doofus. He was wanting to make things as simple as possible, and he thought gathering medical evidence from treating sources, that's a pain in the neck. It takes time and effort, and they don't always say what I want them to say, so I'll find my own pet physicians, and I'll get them to say exactly what I want. I won't bother with gathering the medical evidence. Most of the ALJs in that office probably thought very little of the reports that Khan was submitting, these special reports, and he probably had somewhat limited success with them because of this, because he wasn't gathering medical evidence, or maybe he did gather medical evidence for real when they were assigned to different ALJs. I don't know exactly how he was doing things. Social Security isn't remanding those cases that were sent to other ALJs. You go, wait, what, huh? I thought the problem was these phony medical reports. If the problem is the phony medical reports, that's a problem regardless of which ALJ received those phony medical reports. But no, Social Security is only doing this to those that were done by Judge Daugherty, I'm not sure he pronounces his name. It's like they're trying to pick out this one ALJ because he was approving 99% of his cases. Well, that's aberrant, that's weird, he shouldn't have been doing it. But the same problem existed with these other ALJs who are approving 40 or 50 or 60%. Why didn't you vacate those decisions or remand them for new hearings? Same evidence was in them. Aren't you just targeting this ALJ because he had a high reversal rate? You're not targeting the other ALJs who have very low reversal rates. Anyway, to get back to the categories of medical evidence to get, you first of all need to look at Social Security's file. Whether you go online and download a copy or whether you get a CD, my guess is if you're only doing 1 or 2 or 3 cases, you're just going to use the CD. Get it and start looking at that. The claimant has filled out forms for Social Security telling Social Security what medical sources they've seen up to that point, which will be at the time around the time, up to the point they filed a prior request for hearing, which is going to be several years ago. So this is going to be old, but we're only concerned with old stuff, so it's pretty important. But you need to understand that's if claimants don't always put down everything on the Social Security form that they should. And it's not because they're trying to keep anything from Social Security, it's because they get confused and forgetful. Social Security claimants, on the whole, are extremely confused and forgetful. It's because they're sick. It's also because usually they're scared and confused and not used to dealing with bureaucracy, and they make mistakes. Not out of any effort to deceive, but because they just get confused. So don't take the list they've given Social Security as if it's the only thing. You need to ask them yourself. And when you're talking with them, you need to use your mind. If the claimant tells you, I'm disabled by low back pain, I got a bad knee, and I got a heart problem, and they only tell you the name of a general practitioner, a family doctor, you need to ask them, okay, did you see a cardiologist about your heart? Did you see an orthopedic surgeon about that knee? Did you see a neurosurgeon, neurologist, whoever about your low back? Ask them about those because they often forget to give those to Social Security. If they tell you that they had, let's say, a knee replacement, or they had a stent implanted for their heart, and you don't see a hospitalization mentioned, ask them, what hospital? You must have gone to a hospital to have this done. Where did you have that knee replaced? Where did you have that stent put in your heart? These are the sort of things you need to use your brain, your wits as you talk with these claimants to try to get the whole picture here. Now, once you start getting it, there are certain categories that I recommend you get. And I'm going to recommend that you get them basically only up to the time of the prior ALJ decision or thereabouts. Why wouldn't I say get it up to now? Because that's putting a much higher burden on you to get additional medical records, and it's not going to do any good before the ALJ. Because the ALJ can't consider this later time period. If the claimant had a heart attack after that prior decision by Judge Daughtry putting them on benefits, you can't use that. You should be able to, but you can't. Okay, so things you need to get for this prior time period: hospital discharge summaries. Some of you may be used in your personal injury or practice, something like that, to asking for an entire hospital record. An entire hospital record, even for a short stay, even for 3 or 4 days, can be literally 1,000 pages. Don't do that. That's expensive, and the ALJ doesn't want it. You don't need it, the ALJ doesn't need it, and it's expensive. Don't do it. Generally, you want to just ask for the discharge summary. Discharge summary is what is written up at the end of the hospitalization to summarize what happened. And normally that's all you need. There are some other things from the hospital report that you may need depending upon the circumstance. If the claimant has had surgery, the surgeon has to write up an op note, an operation note, describing what went on during the surgery. You may or may not want to get that. Just depends. Often discharge summaries can be a little hazy, and you need the op note to figure out exactly what was done. If they have a certain procedure like catheterization, that's a heart test where they run a catheter or tube up from your groin to your heart. It takes some measurements, inject dye, look around at your heart. Those are important. But generally, you don't want a whole lot of other stuff. Definitely don't want nurses' notes. You don't want the TPR, temperature, pulse, and respiration rates, where they keep coming around to your room every 15 minutes to wake you up at night to take your temperature and blood pressure. You don't want those. You don't want lab reports. You may or may not want x-ray reports. Just depends on the circumstance. But keep it down. Don't run up the expense on yourself. Don't get this huge file to overwhelm the ALJ. That's not going to help anybody. Okay, I didn't put it in my materials, but you probably want to get ER reports, emergency room reports. The only problem with them is that ER reports have become more and more over the last few years, at least in my area, a two-edged sword. Unfortunately, there are more and more claimants, people going to emergency room on drug-seeking missions. And I expect that happens here all over the country as well. You may end up with a dozen or 2 dozen reports of emergency room visits where the claimant comes in complaining of, I got a toothache, I got a backache, next time it's my knee hurts, next time it's back to a toothache, and they're seeking narcotics. Those are problematic. But they may be going there for other things. They may be going there, let's say, because they keep having complaints of chest pain and they're told to come back if you're having severe chest pain, and then may be reassured each time it's not your heart's okay. Those reports can still be useful because they tend to show the underlying problem of anxiety. So the ER reports, even if there's a bunch of them, I'd say go ahead and get them, but realize these can be a two-edged sword. You may be seeing evidence of drug-seeking behavior in them. Okay, one special thing to be pay attention to are VA records. Is there a VA hospital here in Lexington?
Yeah.
There is. Any others in the state or area?
Huntington, West Virginia is near us.
One in West Virginia. Okay.
Nobody's in Kentucky.
Okay. The VA clinics around the state?
Yeah.
Okay. VA records, all the VA records, with one big exception, should be at any of these places. So if the claimant's been going to a VA clinic, but was hospitalized a couple of times at the VA hospital here in Lexington, all those records should be available through the VA clinic in whatever place it was. So you're going to write there, or maybe you write to the VA hospital here in Lexington, and to request all those records.
Charles?
Yes.
This is something we just discovered very recently about the VA.
You good?
Vets now have access to their own records directly. There's a website called myhealthevet.com, I think it is. Might be .gov. And they can sign up to get access to their own records. They have to have what is called a premium account. It's not money, it's just you have to give them a little bit more information. And then the vet will have a username and a password that he or she creates. And then he can go in and he can download it all, just like that, and it's free. So look into that. I can post that on the listserv too. How to get registered for it. We've got a standard letter we now give vets for that, and I'll put it on the listserv rather than.
Let me repeat so we make sure the sound gets on the video. Bruce is talking about vets now have access to their own medical records online. There's a process by which they can sign up to get access, and it's available through the VA website. My understanding is a little more complicated than Bruce indicated because they have to, I think, go in person to a VA facility to get certified or whatever.
No. You can do it from your home.
You can do it all in the office? Okay. I haven't done it yet. I just started looking at it myself. I don't think it's been available too long. But VA records can be very important. There's a lot of your clients are veterans and are getting medical treatment through VA. Okay, the one VA source that's not on their system, as far as I know, is VA regional office records. Okay, claimant files a claim for a VA rating. Let's say they've got a 0% rating and they want to get a 100% rating. VA will look at their medical records and maybe make a decision on that, but they may call in this claimant for a medical exam at a VA regional office. Those are very complete examinations. They're very nice, very useful, very helpful. Those are kept separate, and you have to write the VA regional office separate from that. Now, I don't know, where's the nearest VA regional office here? Does anybody know? Okay, anyway, you look on the VA website, you find, or you can ask, your client, were you sent for a regional office exam? And they will tell you, yeah, I was sent to wherever, and it may be, I don't know where. In North Carolina, they're all sent to Winston-Salem. Okay, psych records, psychiatric records.
Charles Louisville.
Louisville, okay. So, ask them if they've been to Louisville for one, or there may be one in West Virginia that's closer to some of them, I don't know. But just ask them if they were sent to a VA regional office, if they're getting VA benefits and may have gone through this process of trying to get a rating or an increased rating. Psych records. Are there there must be some sort of free psychiatric care here in Kentucky? Yeah. I mean, is it through some sort of regional mental health centers or
Everybody
private
has it.
contractors or what?
Everybody has, at home it's called Mountain Comprehensive Care, Hazard, Kentucky River Community Care.
Okay,
There's
so
all-
there are various community mental health centers,
Okay,
basically?
yeah.
Okay. So most of the claimants probably are going to be going to these. Some may be going to private psychiatric care, depending upon whether they have medical insurance. These, you need to get the records from that facility. Now, you need to understand that sometimes there are two places you're going to write to for psychiatric records on your clients with psychiatric problems. One is where the psychiatrist is, and the other is where the therapist is. At least that's the process where I am. At least those in private practice, they will have a psychiatrist whom they may see once a month, once every 3 months, once every 6 months, primarily for medication adjustment. They have a therapist whom they may see twice a week, or once a month, or once every 3 months. They're going to see more frequently than the psychiatrist. And this person may be a psychologist, they may be a counselor, they may be a psychiatric nurse. There are all sorts of categories they can fall into who are able to offer this sort of treatment. They may be in a separate facility. So you need to get those from them wherever the heck they are. Prison records. Some of your clients may have gotten out of prison. Yeah, the prison records can be important. They can't get benefits during the time they were in prison, but those prison records may help you establish what happened. The claimant may have had a heart attack or broken leg or whatever while they were in prison. And in Kentucky, anybody know whether you write the individual prison or the central offices of the prison when the guy's outside the prison's left? Nobody knows. Okay. I would just suggest writing the individual prison, and they may forward it on to their headquarters. It's just a question of where the medical records go after the prisoner leaves their system. Because we hope you're not going to be dealing with people, or too many anyway, who are currently in prison. Those cases are pain in the neck. School records, somebody's mentioned those. Those are important, primarily improving what we used to call mental retardation. We're calling now diminished intellectual capacity. Social Security wants to prove not only that you test out low on IQ tests now, but that this originated in childhood. That's not something that just, they want to believe that you're faking it on the psych exam now, psychological testing now, the waste. They want to, but if you show them the school records, you may be able to show back then, you may be able to show, if nothing else, that the claimant had terrible grades back then. The claimant may have had psychological testing when they were in school. Schools do a whole lot of psych testing in North Carolina, I'm sure in Kentucky as well, for purposes of placing students in IEPs, individual educational programs. So those can be very useful. Now, I've got here types of medical evidence you might want to obtain, but I wouldn't. Medical evidence after the relevant time period. Now, if the claimant's been seeing the same physician all along, I wouldn't say, just give me the medical records from 2001 to 2008. I'd say, okay, give me the records from 2001 to the current. You may as well, if you're writing, you may as well get the whole batch at the same time and submit it. But if it's a physician the claimant just started seeing after the prior Judge Daughtry decision, then I would not bother getting that. Just let it go. That's for the new claim, or if the case gets remanded for a new hearing. Same thing mostly with hospital reports. I would not get them after the date of Judge Daughtry's decision unless it's something that relates to the time period before that. Let's say the claimant has a heart attack or stroke shortly after. Well, let's say they have a heart attack shortly after Daughtry's hearing. Well, that may relate to their condition before that hearing, before that decision. So you want to get that. Opinion evidence. You've heard about getting that. The problem with opinion evidence that you get now is that it's several years past date. If you get an opinion now from physicians saying a claimant is disabled, how much good does that do in proving that the claimant was disabled in 2008 or 2010? Not a lot. So that's the problem. You can ask them, okay, how was your patient doing back in 2008 or 2010? But that they're going to be reluctant to give you that kind of opinion, and it's going to be really not terribly helpful. Now, some of you are going, well, how can I win the case without opinion evidence? Easy, that happens all the darn time. We all win cases when the opinion evidence comes in contrary to our client. The doctor may say, your client's not disabled. We submit that to Social Security. We're supposed to submit everything, and you're supposed to submit everything, good, bad, or indifferent. So do it. But you can still win. I've done it plenty of times. Probably the others have too. If they've been submitting the adverse evidence, we now have a specific regulatory requirement that we do so. But opinion evidence is not the be-all and end-all. It's important, it's useful normally, but in this situation, not so much, unfortunately. The other thing, don't bother, I would say don't bother too much with trying to get in these questionable medical reports that Eric Kahn submitted to Judge Daughtry. If you want to make a pro forma motion, Judge, I think you ought to admit that, fine, but don't make it the focus of your argument because the ALJ can't do anything about it. The ALJ may or may not be sympathetic to you, but there's no point arguing with them because they can't do it. That's an argument for the federal district court later on about whether or not these should have been admitted to the evidence, and the concerns about the validity of these reports should go to the weight of them, not to whether or not they're admitted. You definitely don't want to try to get consultative exams. A consultative exam is Social Security sends the claimant to a physician for a medical exam at Social Security's expense. Well, what's that current one done in 2015? What's that going to tell you about the claimant's condition 5 years ago or 8 years ago? Not a whole lot. The ALJ is not going to want to order it, and you can't blame the ALJ for not wanting to order it because it's just not going to do any good. This is one of the things that's just hard to wrap your mind around, the procedural status here, that we're limited in what we can do. The time period is limited, and that's causing the claimant's problems, and that's why it's so vitally important to file a new claim. In every case, file a new claim. I would close my materials in medical release. Probably all or almost all of you have one that you use in your office anyway. One problem with medical releases is we've seen more and more in North Carolina, I think it's all over the country, individual hospitals and physician practices demanding their own medical release. Does that sound familiar to some of you? Yeah. What happened was HIPAA, Health Insurance Portability and Accountability Act, came in and altered the requirements for medical releases. I and other attorneys quickly modified our medical releases so that they're compliant with HIPAA. The medical release I'm using says on the top of it, HIPAA compliant, just to tell them that, but they still refuse it. What happened is that their own lawyers said, just don't take any chances. Here, I'm going to draft one for you, and you make them do that one. This is a pain in the neck since we have in our system, our office, it must be at least a couple of dozen of these for individual hospitals and physician practices, and there's probably a whole bunch of them in use in this area of Kentucky and West Virginia by various hospitals and medical providers. on the listserv, you're going to be needing to be sharing these around so that you get so you don't have the process where you're sending a request to a hospital, they then send it back to you, then you got to get a new medical release, then you have to send it to the hospital again, then you got to get the records back, and by the time you're done with this, the hearing's been over with for a couple of months. We want to shorten this process by getting these, so please share these on the listserv. When we, if you know about these or when you encounter them, so that we can, make this process as simple as possible, and so it does not take as much time, any more time than is needed. Now, how much more time have I got? Okay, I'll keep talking until somebody shuts me up. Okay.
1:15, I think.
1:15. Okay, I've only got three more minutes. We've talked about different types of Social Security claims. You've heard about two different types. Disability insurance benefits, that's based upon your past earnings. You have to work 5 out of the last 10 years before becoming disabled to get it. Okay, that's one type of Title II benefit. And then there's SSI, Supplemental Security Income. Doesn't matter whether you worked in the past or not, you got to be poor plus disabled. Unfortunately, I have to tell you, that's not the end of the story. There are other types of disability benefits that are probably going to be adjudicated here. Disabled widows and widower benefits. These are benefits based upon the account of the decedent. You have to have been married at least a year generally, and you have to become disabled in 7 years after the date of death or the last entitlement to mother's or father's benefits. That gets complicated. I'm not going into that anymore. You're going to have to ask on the listserv about that if you got a disabled widows or widower claim as part of your case. Disabled adult child. This is a claimant who is trying to get disability benefits on the account of their mother or father who is either deceased or is on Social Security benefits themselves. The claimant must become disabled before age 22. Again, just ask on the listserv if you've got a DAC claim, disabled adult child. Blindness cases, we probably might have one at most in the whole 1,470, but earnings requirement very different on blindness cases. If you got alleged blindness, statutory blindness, ask about that. The thing that's most concerning me is SSI children's cases. These are completely different. Almost nothing you will have heard today has anything to do with SSI child's cases. So if you get assigned one of these, really ask about it on the listserv, because you may have a very challenging situation, and you're just going to have to ask about those and get help. So anyway, just to go back to my main points, is everybody on the listserv now? Okay, I'm not giving a saying they're not. Okay, I'm going to see you privately, and we're going to get you signed up. The second point, you understand that the only time period we're concerned about in these hearings is the time period up to the prior decision by Judge Dahlgren. Everybody clear on that?
I'm not sure about that.
Well, why are you not sure?
I'm not sure about if that's going to be the only time period they're going to be looking at or not.
That's what they say.
Okay.
I don't think that's what they should be doing, but that's what they're saying. It's crazy.
There's some way we can clarify that.
The notices of hearing, I mean, they put it in the
I've not seen any notices of hearing yet.
Okay, it's in the HALEX materials. It's HALEX Roman numeral 1-1-3-25.
I'll let you share that with me in a minute.
Okay, it's in my materials. If you can download on your smartphone, you can see it there. Processing multiple cases where fraud or similar fault is involved. And it was designed exactly for these cases and no others.
Let me ask you this.
Yeah.
So, in essence, we are going to be having a de novo hearing?
Yeah.
A new hearing?
Yeah.
But it's only going to be evidence up to the previous hearing?
Yeah.
No, nothing?
You can submit the more recent stuff, but they're only supposed to consider it to the extent it is relevant to the prior time period.
So, as you said earlier, if there's evidence that like a heart condition or something that might corroborate the previous decision,
Yeah.
that would be relevant.
Yeah, if the claimant's been going around complaining of, I'm feeling weak and tired, run down, and I've got numbness in my arm, and they go around saying that for 3 or 4 years, and finally, after the Judge Daugherty decision, they go see a neurologist, and the neurologist does an MRI and says, you got multiple sclerosis. Okay, definitely relevant stuff. And that comes up, you know, with this later diagnosis, something. MS, lupus, notorious for taking a long time to diagnose, and the symptoms seem very vague and hazy, but then they show up later on the test. So you may have something like that, but otherwise we've just got this very limited time period. But for the time, everything after that, we do the new claim. The new claim cannot give you full relief. On new claim, it's limited as back benefits. SSI back benefits can only go back to the day, the month after the month in which the claim's filed. Title II benefits, disability insurance benefits, they can only go back up to 1 year prior to the date of the claim. So if you file a claim in 2015, if you file a claim in August 2015, SSI can begin in September 2015. Disability insurance benefits could begin in August 2014. But we've got a time period going back to 2008, 7 or 8 or 11 or whatever, and you'd like to get them benefits for that, and you've got to do that on the old claim by getting that remanded. So, you know, you need both. You know, you're improving the claimant's chances of getting on benefits. If you can get the new claim approved, don't worry about the overpayment. You can probably get the overpayment waived. Even if you can't, they're only going to have a limited repayment amount. They're going to get a monthly check or checks so they can survive. We're worried about survival here so they don't commit suicide, so they can live, so they have Medicare, Medicaid, whatever. We're just, you know, we can deal with the overpayment issues. They can't deal with the nothing issue where they're getting no benefit. So new claims, vitally important in essentially every case, and that's the first thing you need to talk about with these claimants is go file a new claim, and they're going to have a hard time understanding it, and this is one of the times where you sort of have to pull out the lawyer card and say, just do it. You know, don't ask me why, just do it because I said so, because it's important. I'll explain to you, you ain't going to understand it, but just go do it anyway. And sometimes you just got to do that with clients. They're never going to understand. They're just going to rely upon, you know, your judgment, your knowledge, your experience.
Could you just clarify what you and Tom were talking about, the Halleck's reference about what the date is, it's not clear, so. when
Yeah.
it's come up-
You can look, I mean, you can look at the materials I've uploaded, you can look online, HALLEX, H-A-L-L-E-X. It's a manual used for hearings and appeals of Social Security. It's Roman numeral I-1-3-25. The basic source material for what's going on. This was issued June 25, 2014. Specifically for these cases, prior instructions had nothing about limiting these redeterminations for fault or similar fraud to the time period up to the prior ALJ decision. This had never been done before. No prior HALEX or instructions never said the claimant has no evidentiary hearing on whether there was fraud or similar fault. No prior HALEX had said that the Office of Inspector General can just instruct ALJs to refuse to consider certain evidence. In fact, prior HALEX issuances, in fact, the issuances that are still in there for every other case of alleged fraud or similar fault, say that the claimant gets a hearing, an evidentiary hearing on whether there was fraud or similar fault, and indicates that the issue of whether this medical evidence should be considered and to what extent is just an issue for the ALJ to deal with. To me, it's just an obvious denial of due process to say the claimant gets no hearing on this issue of fraud or similar fault, gets no evidentiary hearing on whether this evidence could be admitted, and if so, to what extent it should be considered. Yeah.
Should we then consider those points to be automatically controverted?
You can. I mean,
you have to file something to say.
I don't think you need to file anything to preserve it, but you could just briefly mention, Your Honor, I'm going to raise these issues on appeal about the limits on the time period you can consider and the limits on what evidence and the lack of an evidentiary hearing on fault, fraud, or similar fault. But I don't think you necessarily need to do that because it's, you know, Social Security has told the ALJ not to consider it, so he or she has no ability to go against those instructions. And some of these ALJs may be very sympathetic to your clients and very sympathetic about the situation. They may be confused by it, and they may think it's weird, if nothing else. Yeah.
I'm a neophyte in Social Security. Are the ALJs lawyers or?
Yes, they're all lawyers.
They're all lawyers?
They're all lawyers, and they differ widely in the extent to which they're sympathetic to your clients. The National Hearing Center, in my materials, I downloaded the reversal rates for the National Hearing Center in St. Louis, which is the one that's supposed to be dealing with these cases. You've got Judge Bailey Smith there is approving 23% of the cases she's hearing. You've got, let's see, there's another one here, Judge Doyle, who's approving 19%. On the other hand, you've got Judge Kathleen Scully Hayes, who's approving 71%. They're not fungible. ALJs they're very different. Judge Arnold's approving 61%. They're all over the map here in that office. They're generally low in that office. That's one of the lower offices. That's one of the things that concerns me about this is they specifically assigned it to an office where they knew that it's a low reversal rate in that office. They knew that. I mean, if you do this kind of work, you know that. They knew it. They assigned it there for a reason. They could have picked, you know, a National Hearing Center in Baltimore or wherever, Salt Lake City or some other office. They selected this one, or they could have used the local hearing office, but they didn't. Anyway, have a question over there?
Would you talk about this idea of having a video conference hearing?
I mean, I don't like video hearings. Nobody likes video hearings. But in this case, you're probably going to have to as a practical matter, at least in some cases. You have to if you can't be there at the site with the claimant. You're going to end up with a three-way video hearing. Three-way sounds, I don't know, salacious, but with you on one part of the screen, the ALJ on another, and the claimant on a third part of the screen. Social Security has a technical capacity to do that. It has been extremely rare for them to use it, and I fear that there will be technical problems with the three-way hearings because it's so rare. We will see. It will be better to be there, and it will be better to ask to get the claimant there. The claimant is only being given, I think it's 30 days to object to a video hearing. So the time period to object to a video hearing may have passed. It will be better to force these ALJs to travel to Kentucky to do these hearings because that's going to put it off longer if nothing else. And they're not going to want to travel here. I can tell you that. So, you know, I'd say avoid video hearings if you can, but if you have to, it's not the end of the world. In the end, it's probably more important who the ALJ is, and it's certainly more important what the evidence is than anything else. And just remember, you know, there's only so much we can do as lawyers. If the evidence ain't there, it ain't there. You know.
What grounds can we use to object to a video hearing?
Oh, you have an automatic right to object. It's just when. You don't have to tell them why you don't want a video hearing. All you have to do is just make sure you do it within the relevant time period, and it's automatic.
And that's going to be, we're going to get on this site, we're going to see the notice of the hearing, and then we have 30 days to come objection.
No, it was 30 days from when they received the notice that their case was remanded back for a hearing. So that's what I'm saying is the example I showed that for 30 days roughly before she came to see me in the office. So it's 30 days from when they received this notice telling them they have 30 days. And if they didn't exercise the option, it's a video hearing.
So by the time we get most of these, that's going to be fine.
Yeah.
Yeah, and let me tell you what we've done at AppleRed. We have not instructed people to object to the video hearing. We have said that that's up to them. They should do what they want to do. And the reason we didn't is because if all of these hearings have to take place in Eastern Kentucky, it limits the pool of volunteers. With NOSCAR being able to do nationwide recruiting and regional recruiting, we've got more attorneys who can do it by video. So we thought that it would be better to have an attorney by video than no attorney in person. So that's what we've been doing at AppleRed.
And one thing I should add, Social Security may be limited on what they can do simply by lack of available hearing sites. They have to have the video equipment to do the video hearing. There are a limited number of rooms where video is available. And they're trying to do 1,470 hearings in 4 months, plus all the hearings that the ALJs locally were doing routinely on new claims. They're going to have a hard time coming up with the hearing rooms to do this in, and that's a good thing. It puts it off. The longer you put it off, the better. You know, if you're talking about, if you're not using video equipment, they can just use a motel conference room. But if they're using the video room, they're limited to only a very relatively handful of rooms.
I'm sorry?
Being raised on the defense side of the bar, we always believe delay and moving things off is good. So for those of us that are in Eastern Kentucky that are taking these cases, what I'm hearing you say, it is to our advantage to request that it not be video conference.
If they're within the time to object, that would be between the attorneys and clients. That would seem to make some good sense. John?
Is the HALEX, is there a law that it has to enforce the law? I'm just wondering if we have to start at the ALJ hearing, wouldn't you object to that provision that they published and take it all the way up, or it may even be something in the pending case?
No, regulations are the only thing that have force and effect of law. These are not been adopted through the notice and comment requirements of the Administrative Procedure Act. So it's simply an interpretive interpretation, agency interpretation. I mean, there's an open question about whether it really is binding upon the ALJ, the HALEX, but we're not going to get into that. A lot of ALJs don't think they are bound by HALEX, and to some extent I don't think they are either. But anyway, they're bound by it as a practical matter, but certainly the U.S. District Court is not, and I expect this is, if there's not a preliminary injunction entered here, there's going to be all kinds of litigation for years to come on this and many other issues. Yes?
I have no experience in this field, and I appreciate the conversation about what records to get and what not to get. But I'm a little bit more concerned about the nuts and bolts. Once we get the information that we think is going to be favorable, do we submit it ahead of time, or do we?
Yes, absolutely. The ALJs get testy if you come in with 100 pages of medical records. In fact, they get testy if you come in with 5 pages of medical records. You definitely want to submit them as soon as you get them through the online system, if possible. If not, with the barcode, fax it to them, you'll get in the file, but as soon as possible, and you'll make the ALJs much happier with you.
I'm very concerned about the idea of not going in and at least requesting that these excluded reports be considered.
Don't do it.
Yeah, I mean,
You're not going to hurt anything, just don't make a big point of it, because there's no point arguing with the ALJ, because the ALJ can't help you.
I mean, if it's truly vacating and we're starting from scratch, then I'm inclined to just submit the reports and then ask to examine the claimant to corroborate it. And
yeah. You may want to do it. I mean, you don't have to submit the reports. They're already there in the file. They just have been pulled out of the exhibit file. They're in the junk file, which is what we used to call it. You can ask the ALJ, I want you to move that report from Dr. So-and-so from the junk file to the exhibit file. He or she can't do it.
Okay, that's exactly what I needed to hear, that language, that I can say that on the record and then...
Just don't make a point of it because you're arguing with the ALJ, asking to do something that he or she can't do, so no point, making them angry. And just one last thing, if you're coming in from a personal injury or workers' comp background, you're used to an adversarial situation. You're looking for who's my adversary, who's opposing counsel. I want to argue with opposing counsel. The tendency is to cast the ALJ as your adversary. No, he or she isn't your adversary. It's they're like the jury. You're trying to make nice to them. You don't want to argue with them about something unless you have to. You know, you don't want to have arguments with them you know you can't win. You're just going to make them annoyed with you. So just, you know, keep this low pro forma and you know, don't argue with them unless you have to, and just, you know, you're trying to persuade them. You're not trying to beat them over the head because they're your adversary.
I just wanted to say one thing before Bruce talks about vocational experts. Well, two things. One, when somebody actually has a hearing and has represented somebody at a hearing, please give a little summary of how things went on the listserv, because as you can tell, we all have a lot of questions about what the judges are going to consider with evidence, old evidence, new evidence. Are they going to be sympathetic? Are they not going to be sympathetic? And obviously, everyone's not going to be the same, but if any of you are having those hearings on September 17th and 18th, put a description on the listserv. That will help everybody else for future ones. And also, I don't know if this was mentioned, but Charles just briefly said, a hearing is a non-adversarial proceeding, and also as an administrative proceeding, the regular rules of evidence don't apply. So when you don't have to, I don't even remember all the rules of evidence, but they don't have to pass all those in order to get the documents into the Social Security file.
Profanity. The way the agreement with the clients was, the way I keep them updated is they go to my public Facebook page. I'm the only Ned Pillersdorf. And then you'll see the string of comments. Hey, I just got a letter today, blank, blank, blank. It says blank, blank, blank. And you'll get a good sense of how confused they are, how angry they are. It's also informational. I think what's going to start happening is they're starting to get letters giving them hearing dates. And that's when the chaos is going to start. But if you want a good idea kind of what kind of letters they're getting and whether the clients are understanding what's going on, go to my Facebook page and you'll see hundreds of comments of clients, and you'll have to wade through the profanity and the other stuff, but you'll have a good idea what's going on. I'm sorry.
What did we decide, break, no break?
No break.
No break, okay. All right, I want to start, you've got several different people that have different experiences over the years, and so you're going to hear different things. I agree that the time to get out of the video conference hearing is gone, that ship has sailed, but I still think you should ask. You heard me say earlier, these cases are very intimate, and my belief is that they are. I've done probably, I don't know, 30 or 40 video conference hearings, and something does get lost in the translation, in my humble opinion. So, if at a minimum, if you feel like this is what you're trying to do with your client, is get the judge to see who this guy is and what her character is and what really motivates her, and you think that's better off being eyeball to eyeball, there's nothing that stops you from saying, Judge, we still believe this needs to be in person. It's going to be denied, but it becomes part of the issue. The other thing that I want to bring up, and this is more me thinking out loud than anything else, it's you heard Ned say that there has been no evidence of any fraud on the part of the claimant. None. So if these questions about fraud and similar fault are going to come up, you need to be very clear that the claimant has been separated from Eric Kahn. I would guess that the vast majority of these claimants never met him, never spoke to him, and what happened was, because this isn't just peculiar to Kentucky, claimants go in, they have no clue what they're about to do or what the process is. And they go in and maybe they get a denial and they go get a lawyer, and God help us, The vast majority of them never talked to the lawyer again, or at least until the day before the hearing. And then, at some magical point, a letter shows up that says, hey, here's your check. And they had no clue how that ever occurred. So these people never knew that there were reports from doctors. And it didn't, in my mind, doesn't make a whole lot of difference whether they actually went to see the doctor or not. They're not the ones that were defrauding or deceiving the Social Security Administration. It was their attorney with whom they had no contact and they had no idea. And the whole idea here is to make sure that the judge isn't sitting there confused that maybe the client was complicit in this. And you need to watch out for the idea that maybe you need to try and separate the client from Eric Kahn at some point during the hearing. I don't know, that could get really dangerous. And it's something that you have to go over with your clients very particularly.
I got a question.
Yeah.
You keep on telling people to file a new claim. Is that a claim you'll file with your Social Security office? Is that a file you need to go and file with your attorney? Because you could go to the Social Security office and say something that maybe you shouldn't say or can't remember.
Okay, the question is, if you're going to file a new claim, how do you do that? Do you go into the district office? Do you go to your lawyer? How do you do that? There's all different ways of filing a claim. If it's an SSI only claim, you cannot file it online. You have to go through the Social Security Administration. Either you have to physically go into their office, or you can arrange for an appointment to have the application taken over the telephone. If it's a Social Security disability claim, then you can go online, you being whoever, the client and the lawyer, which is what I would suggest, in the privacy and comfort of the lawyer's office, and you can go online at the website that, wherever Barbara is, ssa.gov, and there's a link that says online services, and you just click on that and follow the bouncing ball. Yes, sir?
Okay, you said earlier that after 5 years, unless they support with insurability.
Correct.
So our folks have worked since 07.
Right.
Even though they report to Social Security, they now go for SSI.
They could. They can file a claim. The date last insured could be anything. It could be a date that occurred before the hearing/decision by Judge Daugherty, or it could be after, but you can still, even after the DLI is gone, you can go in and file a claim. You just have to be able to prove that it started while the insurance was in force. Correct. And the housekeeping thing, I got up here and I didn't tell you any contact information because I want to make sure that you all understand that I'm willing to back you up. If you have questions, you can call me or you can email me. So here's my, and I brought a whole handful of cards and I pulled them from the wrong office. So here's the contact information. The name is Bruce, the last name is Billman, B-I-L-L-M-A-N. The website is Social Security ESQ, that's all strung together, .com. The main number is area code 540-710-1001. And the email is B as in boy, K as in kite, B as in boy, I-L-L-M-A-N, BK Billman at Comcast, C-O-M as in Mary, C-A-S-T.net. If you email me, put the subject line, the con mess. Because otherwise,
fiasco.
Yeah, but just please do that for me. And I will do my best to back you up. Look, I'm in private practice, I'm by myself, so I'll do my best. Okay, I'm here to talk about vocational experts and tell you everything I know about vocational experts in 15 minutes, so we'll have about 10 minutes left over.
You can have a vocational expert. They're testifying about something 5 years ago?
Yes. Yes. Remember, and we're going to go back to the 5-step.
If they weren't vocational experts 5 years ago.
The question is whether a vocational expert can testify about something 5 years ago, correct?
Right.
Okay. Yeah, sure they can. They're still an expert today.
If they were experts today, but weren't 5 years ago.
Doesn't matter, does it? They're an expert about
I mean,
jobs
as a doctor, I can testify about.
It's not temporally limited. He still has knowledge about jobs for all time.
Jobs change.
That's a great point.
But the DOT is from 1981.
And that's a great point that I want to come back to in minute 3. Okay. So we're going to go back to this sequential evaluation, and we're okay at step 1, not working. We're okay at step 2. There's something wrong with the person. We don't have something that meets a listing, so now we're talking about whether the person can do any work. And the entire question turns on what the judge thinks your client can do from a physical standpoint, from a cognitive standpoint, from an environmental standpoint. In other words, how many of these things that the client is telling him, I can't do anymore, does he believe? And whatever it is that the judge believes out of that entire story, that's called the residual functional capacity. And that residual functional capacity is then compared with the demands of the client's past work and see if they match up. And if they do, the judge is going to say, well, you know, I heard you say that you need to lie down 6 times a day, but I don't believe that. I believe you can be up on your feet 8 hours a day and lift 20 pounds, and so I'm going to find you can return to your past work as a lawyer, because there's nothing in there that says you can't. Okay? We all clear on that? And I mentioned as we were going through this that you have to be careful to understand what the demands of the past work are. Now, to your point, since we're in minute 3 now, is that the jobs that he's looking at are only jobs the claimant did in the last 15 years. As a brand new baby vocational expert today, I can still figure out what you did 12 years ago. And there are 2 ways to do that. One is to ask the claimant, and the claimant will tell him, this is what I did. There's a separate way to do it, which actually kind of meets your objection even better, which is the United States Department of Labor has put out this book, and it makes a great paperweight. It's about this thick, no kidding, except it's electronic now. And it lists every single occupation in the world. And there are 12,664 of them. I'm the only guy on the planet who bothered to count them. And the Department of Labor classifies those jobs. They'll give you a generic description. You saw that in the materials for the CNA. And then it will say, and this job is performed at the light level. And light means on your feet all day, lifting 10 pounds frequently and 20 pounds occasionally. And it will classify each job as sedentary, light, medium, or heavy. And the administrative law judge is allowed to make this decision about whether you can return to your past work or not based on how the client described it, but he's also allowed to base it on how the Department of Labor describes it. And so you may have a client who comes in and says, well, I was a CNA and I was having to lift these old people who were kind of heavy, and they weighed 150, 200 pounds, and I had to push them over and turn them to clean them and lift them into the tub and stuff like that. It would be pretty easy for us to show he or she couldn't do that. But wait a minute, the Department of Labor says you only have to lift 50 pounds to do that job. And the judge may say, well, I believe you can't do it as you used to do it, but I do believe you can do it as the Department of Labor says you can do it. You need to become very, 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 one more time, very familiar with the Dictionary of Occupational Titles and how it works. And unfortunately, that too is kind of beyond the scope of what we're doing today. Yes, ma'am.
Do you ever argue alternatives, such as, okay, I think that there's these grid options, they fall within this, therefore they're disabled, or if you don't, then there's these residual things that the rule doesn't apply. Do you do that?
Yes, the answer is, the question is, do you argue alternatives, grid rules versus there's more to this than the grid rules and that's why we win? And yes, the answer is absolutely you do both. But I want to just stick with the past work for just a half a second because that can be a sticking point. The vocational experts all rely on the Dictionary of Occupational Titles. That's their research. When they get ready for a hearing, if they get ready at all, they look in the file, or they're given the part of the file that has the vocational work background information in it. And they look at that, and they look at the job titles that are filled out, and they go, oh, that sounds like a cashier 2, and that's light and it's unskilled, according to the Department of Labor. And that's usually the one that you have a hard time dealing with, the Department of Labor, as opposed to your client's description of the job. The clients usually will be describing a much more exertionally demanding kind of job. You can try to say to the judge, well, he says it's a cashier too, but it's not, it's really something else. So he's just wrong. He's not even talking about the same job she had. But at the end of the day, the vocational expert's word on this is going to be given a lot of weight. You have to get by this question of can they do their past work. I'd say half the time, it's a pretty easy thing to do. One of the places that might help you a lot is if when you go into the file and you look at remember the report from the state agency, the non-examining people, when you look at that, they will have said, sometimes, they will have said, we don't think they can do any of their past work. Well, that's good. If that's what they've said, the judge is going to start from there and pretty well assume that's a dead issue, you've won that issue, and now we're just on to step 5. Everybody with me? Okay. Step 5. In case I didn't make it clear, part of the reason the vocational expert is there at the hearing is to tell the judge, to characterize to the judge what was this person's past work. The judge is not simply going to swallow whole hog what you tell him or what the client tells him. All right, if you get past step 4, then you're at step 5, and the question is, can you do anything else? Your question is, well, don't you want to rely on the grids? Well, sure you want to rely on the grids if they give you a good answer. And hopefully that's the end of the case. But lots of times it's not, because you're looking at the grid rule that says this person is limited to sedentary work, and the judge is sitting there thinking, well, I think they can do way more than a desk job. So even though you think that's the right rule, it's what the judge thinks that counts here. As a I guess kind of a procedural or mechanical manner, the way this all works is you get to the end of the hearing, your client has testified. If you have witnesses that you want to testify, usually that's cumulative and it does nothing more than piss off the judge, but if that's what you want, that's fine. And then the judge will have asked questions to the client, you'll have asked questions to the client, or the reverse order, and then the judge will say, okay, well, let's talk to the vocational expert. And the judge will ask the vocational expert to characterize the past work, and then you get to where the rubber meets the road. The judge will then say, okay, Mr. Vocational Expert, I'm going to ask you a hypothetical question. And I want you to assume that this individual is 48 years old, he has a 6th grade education, he's worked in the past as a construction laborer. I want you to further assume this individual can stand and walk 6 out of 8 hours a day, he can lift 50 pounds occasionally, 25 pounds frequently, and he should not be exposed to pulmonary irritants. Can that individual perform their past relevant work? And the vocational expert will say yay or nay according to whether he thinks the limits the judge set match up with the past job or not. If the vocational expert says no, then the next question for the judge is there anything else that he could do? And the vocational expert will say, sure, they can do this job, this job, this job, and this job. That's mechanically how it works. Very often the judge will ask a set of alternative hypothetical questions. And the first 2 or 3, 1 or 2 or 3, are all designed to get the vocational expert to say, sure, there's work. And then the judge will ask 2 or 3 questions that are designed to get the vocational expert to say, no, there's no work. And typically they're questions like, if I were to ask you to assume, in addition to these things I've already told you to assume, where he can work, if I were to ask you to assume he was going to miss 3 days a month because of absenteeism, because of his condition, oh no, Judge, there's no work there. If I were to assume that he can't keep his mind on his business more than 80% of the day, oh no, Judge, that wouldn't be acceptable for anything. So he's covering both sides. And they'll say, okay, I don't have any more questions. And you're sitting there going, whoa, you want to let me in on the secret, Judge? Which way are you going? And he won't. Have a nice day. So it's up to you at that point to make out of this whatever it is you want to make out of it. Don't be satisfied with the judge's questions. I think that perhaps the biggest point I can make upon you is go in there with your own hypothetical question already set up and annotate it. Now you don't have to annotate it in the question. Mr. V.E., I want you to assume, according to Exhibit 3F, page 7, that this individual can... No, you don't have to do that. But make sure you are firm in your mind that you have established each and every limitation you want him or her to assume. And there's no arguing about this. It's not that the VE is going to say to you, well, I think he can do more than that. Come on, we all learned what a hypo is. There's no arguing about it. He's got to answer the question. And I'm assuming that you're astute enough to know that you don't ask a question you didn't already know the answer to. So hopefully, if you've constructed this question correctly, you'll know what the answer is. No, that person couldn't work. Now again, the judge has to decide whether he believes that your set of facts that you described in the hypothetical are something he can believe or he can live with. And you have to make sure all of those limitations have been set up in the evidence, the medical evidence. And I've got, I put forms in here in the introductory materials, forms doctors can fill out about residual functional capacities, and there's a billion ways to get at it, and I've put a lot of the forms in there for examples for you. And they're all used as foundations for the hypothetical. So you make sure it's set up in the evidence, but for God's sake, you make sure it's set up in the testimony too. You want to make sure your client's about to testify with something that's fairly consistent with that. And you need to be working with your client as you're preparing them for a hearing. Make sure they understand what the point to this whole testimony is. Again, you're going to hear things, you're going to hear different takes on things because we're all different. I don't believe in scripts at all. I do believe in forms. You'll see in the materials that well, take for example, starting at page 87 in the introductory materials, I do what's called a trial memorandum for each and every case. Now the whole reason I do it is it's not a script, but hopefully you all are accomplished trial lawyers, I'm sure you are, and you know that this is nothing more than something to ring a bell for you to remember to ask questions on a topic. But don't use a script, because now you stopped listening. These questions that you ask people during the hearing have to be free-flowing. They have to be spontaneous. You have to be listening really, really carefully. And I do these memos so that I can write notes as the judge is asking questions. Instead of trying to scribble the whole thing down, at least I've got, places to put things, and I know what it is that I'm trying to address here. The same is true with the vocational expert. It gets really hard to sit there and write down the administrative law judge's hypothetical questions because they rock it. I mean, they go through it. Assume the individual is limited to 20 pounds occasionally, 10 pounds frequently, can lift and stand 6 out of 8 hours a day, can bend, squat, stoop, kneel, crawl occasionally, can never climb ropes and ladder. I can't keep up with that. So one of the things that I've done as well that you'll see in vocational expert materials, and it's about 4 pages back, is just a form where I can start filling in blanks as the judge is rattling all of this off. It will help you, I promise. And then I think in the materials as well is a place for you to kind of construct your own hypothetical. And you need to be very swift and very certain in how you deliver that. You all know about tempo and cross-examination. Don't necessarily assume that the vocational expert is against you. They may or may not be. I always start from the idea that they're not. And there may be a lot of information you can get out of a vocational expert by just asking direct exam type questions, open-ended questions, and it won't hurt you. But when you get to the hypothetical, be very swift and very certain about what it is you're asking. Yes, sir.
Neophysical question. Who brings this vocational expert? Is this something Social Security has there at the hearing?
Social Security has a panel of vocational experts, and they are supposedly assigned, they're supposedly picked on a rotating basis amongst the judges as the hearings are scheduled. Social Security pays them, and the first question the judge always asks is, are you aware that even though we're paying you for your services today, that you're an impartial impartial witness? Yes, of course I am. And the vast majority of these VEs, at least the ones I've encountered, this is all they do. This is their living.
Are they on site where?
They're out of their bedroom.
Okay, so they're there by video, correct?
Oh, that's a good question. For these hearings, they could be anywhere. I would think they're going to be with.
They'll be by phone probably.
Deb says they're by phone. Now you have an absolute right to object to a VE or any expert witness appearing by phone. You do.
When?
As soon as you get the notice of hearing. It will say, I plan on using a vocational expert, he will be testifying by phone.
They say that.
In the notice of hearing.
The
If you're
question-
unsure whether they're going to be live or on the phone, you should call the hearing office and ask.
The other thing is, what materials do the VEs have before the hearing?
The only materials they'll have, as a rule, there's a form that the claimant fills out when they first apply. It's called a work history report. And it's just list the jobs from the last 15 years, and then circle how many hours you stood, circle how many hours you walked, circle how many pounds you lifted, sort of thing. And that's all they'll basically have.
Are they present by phone or otherwise during the entire hearing or just in the circle?
They should be. They should be there for the entire hearing. Yes, sir.
What if there's a vocational expert in the initial hearing? Is there some kind of res judicata argument you can make?
Well,
kind of bound by that person?
Well, I'm glad you brought that up. It's a de novo hearing, so I think the slate's quite clean. There should be.
They didn't bother with VEs in these other hearings. They didn't need VEs.
On any of them?
No, because
Okay.
they were mostly on the record.
Okay. Well, yeah, I know most of them were on the record, but there were some.
But it's a de novo.
But what
it's a de
Tom
novo
is
hearing.
saying is that there were never any VEs in any of these hearings anyway. But I'm still glad you brought it up, because the client, in the ones where there were a hearing, and you need to ask, did you go see the judge? You need to ask. And if they said, yes, I went in and we talked for, 2 minutes? Maybe 3 minutes? I don't know. But there's a recording of that hearing, in theory. And if your client testified under oath, I would advise you very strongly to request a copy of what then would have been a cassette tape. Because you don't know what they said, and you don't know whether they're going to try and now use it as some sort of prior inconsistent statement. Look, I come from a horrible jurisdiction. I'm told things aren't as bad up here, but that's not beyond their abilities where I come from. And I've seen a lot of it. So they would have to get the tape, which, by the way, they'll never find. And that's yet another issue, you know? But I think it's important to find out what they said, if they said anything.
That was my concern with filing a new claim. You may go down and tell them something you couldn't remember in 2006.
Well, except this isn't, the comment is, my concern is in a new claim I might end up saying something that was inconsistent with what I said in '06. The purpose of the new claim is not to go back to '06. The purpose is to only go back a certain period of time which was never covered up through Judge Daugherty's decision. So there's nothing inconsistent to say, or if you say something that's not the same as it was 10 years ago, it's only because things have changed, not because you're trying to say something different now. Yes, sir.
Does the vocational expert need to testify beyond the fact that they think this person can do a certain kind of work activity? For instance, you would say, can this person do light work activity? Do they have to identify jobs? Do you have to identify jobs locally that are available?
Yeah, I'm glad you brought that up too. Let me be very, very clear. The vocational expert will never, ever, ever be asked, what do you think? Can this guy work? This is not about their personal opinion or even their professional opinion about what they think the person can physically do in a job. They're only responding to the hypothetical. And now I've lost the point.
Job numbers.
Oh, job numbers. I'm going to get shot down for this, but I'm going to say it anyway. They have to prove that whatever it is your guys can do, that job exists in significant numbers in the national or the regional economies. That's in the statute.
It's all national now.
Pardon?
It's all national now.
Okay.
International.
Okay, it's all national. And you'll read cases if you go back 15, 20, 30 years. That was the issue. The vocational expert testified that the guy in Georgia could be a shrimp boat captain in Kansas. And there are 50 of those, or vice versa. And whether that's a significant number. I have never seen a case won based on that issue, ever, in 36 years. I don't even bother to question them about the numbers. The VEs will say, as part of their answer, this person could be a cashier too. There are 6.2 million cashiers in the national economy. There are 500,000 in the Commonwealth of Virginia. I don't know, and I'm never going to win that argument with them. And I don't know any good way you can do it on the spot to impeach that testimony. So I don't even try. There's more in the materials about some, again, I think kind of goes beyond the scope of what we're doing. But there's some stuff that I've tried to describe in the VE materials about situations where you're between the range of light work and medium work, or the range of sedentary and light work, or you're even in the range where they can't even do all of the sedentary things. And it is a tremendous weapon, but you got to study it. And I'll tell you, it's, where is it? Second page, on the back of the second page of the VE materials. It is a complex argument. It's really not complex because I actually understood it. But I guarantee you, I have yet to run into an ALJ that understands it. At all. At all. So it's a huge weapon, and you should learn to use it.
Could you give us a couple of examples where you've been successfully cross-examining the VE, and what sorts of things you found successful?
Okay.
Sit stand option.
Yes. Yes. It's hard for me to give you an example. The examples that I would give you would only be that the administrative law judge's hypothetical didn't contain all the facts in it. And I'm sitting there thinking, wait a minute, he left out that this person is schizophrenic, and he left out any consideration of whether this person can deal with supervision. And so I would ask a hypothetical that adds that to the mix, or some other additional factor that the judge had left out. And that's why you have to be thinking and listening so carefully as the judge is giving his hypotheticals. The last week, I had a hearing with a judge, and the judge was trying to deny this person, it was the Green Beret, by the way, by saying that he had skills from his past work that he could use in other forms of work. And the vocational expert testified, oh yes, Judge, he has skills from his past work, general clerical skills such as typing and filing. And what you have to know is that skills only come from the work you did. the regulations talk about you acquire skills, but the only place you acquire them is in the work that you did. And so as cross-examination, I said, where do you suppose he learned to type? Examining the body armor? No, he learned to type in high school. Where do you suppose he learned his ABCs? So he could find. Well, it wasn't dismembering IEDs. And the judge accepted that means that those really weren't skills. So there's a successful war story. Yes, ma'am.
I just want to say, in addition to Bruce's material on vocational questioning, we included some material from a recent NASRA conference by
Yes.
Tom Krause and Vicki Fisher. And they have also offered, Tom said if you can find it, a video of a mock cross-examination that if he gets it, can we put it on AppleRed's webpage or?
I have to consult my tech guy, but yes.
Because I don't know how to put it on Apple.
I think so.
So if you can find it, then there can be.
You guys have been really, really patient. I appreciate it, but more, I appreciate what you all are doing. You guys, there's a place in heaven for you. Thank you.
Coming up to finish and confuse everyone. First of all, I should tell you an easy way to reach me, which is my email is Deborah, D-E-B-R-A, at S like Schifrin, N like Newman, S like Smith, snsdisability.com. So it's just, and the emails come to my phone, so I usually can respond. And if you do ConMess, I'll be sure to respond to them right away. I'm very good about checking my emails. Couple of things I wanted to clarify with what Bruce just said, which is, yes, I've had most of the VEs, at least here in the 6th Circuit, which is where we are, have been by phone, and I'm going to read you the language that's in the notice of hearing, because I had the file from my hearing yesterday still on my iPad. You're requested to appear and give testimony as a vocational expert in the above hearing. We will call you by phone for the hearing. So it's the only way you know it is if you see that sentence. But I would say most of them are by phone these days. And if you get a judge that will call a doctor, for any reason, I don't know why, most of the time the doctors are also going to be by phone. When you do see the notice of hearing, though, I would post on the listserv the name of the VE, the vocational expert, so everyone can give you experience they've had with that VE, because each VE has a set jobs that they love to give. Okay, such as a dresser. I love that job. A dresser is someone who dresses envelopes by hand. Okay, you get the idea here. Yeah, not many people do that these days. So you have to be aware of that. The DOT is online, but really the best website, like I've said before, is ssa.gov, because you're going to want to go through, there's a list of rulings, Social Security rulings, such as if they have diabetes, which there was a listing for diabetes at the time. Most of these people at hearings, there is no longer, but there is a ruling regarding diabetes. Obesity was a listing back at the time, it no longer is. There's a ruling for obesity. There's also a ruling for chronic fatigue syndrome, for fibromyalgia. So these are things you're going to want to look and read the rulings. Now, I've been listening to the questions here during the day, and there's one gentleman asked a question about submitting favorable evidence. The answer is you have to submit all evidence. Social Security came out with regulations in April, sometime this past year. We now must submit everything. Be it duplicate, be it good, be it bad, it must be submitted. So if you request any medical evidence, know that whatever you request, send it in. I mean, files have gone, our hearing office chief judge just had a meeting Thursday with us and was discussing that hearing files have gone from being 400 pages of medical evidence to an average of 1,400 pages of medical evidence. Yes?
This may be a dumb question.
There is no such thing as a dumb
Well, I
question.
don't know. I'm gonna try. This is a completely bizarre situation because you're asking us to have a hearing in a vacuum that shouldn't exist back 5 or 6 years ago. So we're applying the rules Social Security would use now, 2015, or is there an argument that former rules should have applied, or, you see the confusion?
That's one I wouldn't play with. He asked whether you could argue that you don't have to, I would extrapolate, you don't have to submit all the evidence because that rule was put into effect in April of 2015. We're acting as if the hearings took place back in 2010 or 2011. And it's wonderful theory, but I wouldn't try it because they're really adamant about all evidence being submitted.
If we submit it, do we then have the capability of pulling out portions such as like discharge summary as an exhibit?
No, you must submit every page of the.
I submitted all, but if the hearing, we're not going to get 1,500 pages, how do I draw attention to discharge?
That's what I was just going to go through. So one of the things is when you submit evidence, you're going to submit it electronically, like I said. You'll request a barcode, and medical evidence will be going into the F section, so you need a barcode for the F section. If they've worked, you need a barcode for the D section to send in pay stubs. And the issue here is not just working where they've paid into Social Security, which I love, people who think this. I don't know how it works in Kentucky, but in Ohio, the teachers don't pay into Social Security. They pay into what we call PRS. Does that work here in government employees? Okay, so same thing here. So people think that because they didn't pay Social Security, that Social Security doesn't realize they were working. Au contraire, there's a report that shows earnings from both Social Security and any other source. So yes, government is aware that they've been working, yes.
You go back, I've done comp.
Huh?
So what you would do is you would send everything in, but then you designate specific pieces as that.
Well, that's what I'm going to say. One of the things I suggest is, besides the trial memorandum Bruce discussed, is we prepare a pre-hearing brief for the judges. And I do mean, contrary to what all of you do in your practices with lengthy pleadings, this is 2 to 3 page letter where I summarize the key exhibits and set forth my theory of why my client's disabled. I don't think I've ever had one go over 3 pages. Just because I know the judge, if I did, the judge wouldn't pay attention to it.
Do you attach the?
No, I referred to page, to the exhibit number, no, there's like a 13F/7. And I refer to the actual page of the exhibit because the judge will have that. The other practical thing that none of us have talked to you about, but what you need to do is when the clients come to see you or when you receive this sheet of paper, I'm all ready, you need to send them out what's called a Form 1696, the appointment of representative. Because if you don't send that, they don't sign it, you don't sign it, you don't represent them according to Social Security. So that form has to be submitted by mail. And what I would do is I would have them sign 3. 1 for you to keep in your records. Not that I don't trust the government. 1 I would send to the local office. And I showed you how you can find a hearing office located. You can also find the local office. It's called local office search. And you put in the person's zip code, not yours, but where they live, their zip code. And it's going to give you the address of the local office. So if I get on, I can show you. Some of these, it's just, like I said, if you, Intranet is the new best friend with practicing Social Security disability. No, because you don't have access until you send in the 1690. If you're filing, yeah, if you're filing an application. But the other, and just do local office search. Maybe it'll come up. You must, and I would send it to the local office, and I also would send to the hearing office. So you would send it to St. Louis. So you want to send that 1696 all places, and then with the cover letter to the hearing office, which is St. Louis, I would ask for a copy of the disc.
You can get a copy of the Form 1696.
Online,
on Social Security's
on Social Security's website.
And it actually comes in 3 parts now, one for your file, one for ODA.
Why is this not available?
Is it correct that you can't register for the ERE until you go to 1696, until you've actually got a claim?
No. You can register for some odd reason, it's not letting me do it. But just so you know how to look for things, if you go up at top of Social Security's website, it says third parties, appointed representatives, and it's going to give you everything you need to know, including, there's a list here of forms frequently used by representatives. So if you go to there, there's the 1696 appointment of representative. No, the form you're going to have to file with them to get the online access, and we'll send that to you, is the 1694 and 1699. And I think Bruce said he's going to send out, wait, I think he left. Bruce is going to send out the instructions. And so just see, so this is what the appointment of representative form looks like, maybe. I love all the instructions. There it is. So you have the name and whether or not you're, and what you were talking about earlier with the, one of the things is whether I'm an attorney, whether I've ever been disbarred. So all those questions are there, and you put in your information and just submit that. But I would submit, like I said, I would keep a copy for yourself, send one to St. Louis, and send one to the local field office. So this way you're covered, and this way you'll be able to, they'll know you represent the person. And that's the first thing. And they get the disc, look at the evidence, and see what was there and what arguments you can make. I would read Judge Dougherty's decision. I also would read the notice from the Appeals Council. And then you're going to start having questions. And one of the things is if you do want to send forms to doctors, any specialized forms, we have about 20 in our office we use based on what the disease is. So again, if you email me, I'll be more than happy to send you off one. Next time I'm in the office, I'll go into our database and send it to you.
Deborah?
Yes.
Getting back to a question you answered before about the application of the current rules to the past. You said there was some conditions that now have a ruling as opposed to a previous listing.
Yes.
If the listing and ruling are different, and we're talking about years ago, what are they going to use?
I would argue then that you want to go back and use the old rule, the old listing.
Okay.
Because it wasn't, and that's where in the POM section, and I give you a list of some of the more recent, but if you go to the POMs, and we'll see if this works. Let's see if this works. POMs, there's the POMs. If you go to the POMs, here it is, I think. We hope. If you have, anything you can look at is going to be on this website. The regulations, the rulings, if it works. Sometimes it does, sometimes. The other thing they have is when you know which your judge is, there is the website that Charles put out, the disability judges, but Social Security also has all of the information you could possibly want on their website, including they have a list they put out of ALJ disposition data. So once you know who the judge is, here's the POMS home. And if you go to disability insurance and obsolete rulings, there it is, obsolete rulings. They're all going to be there, and you just have to go by what the body type is. The example was, let's see, diabetes was it here? Nope. Nope.
Reserve this issue with the ALJ.
I would put in writing. There's also special rulings that will provide, at least I'll provide, a whole summary of a paragraph or two that we put in. Social Security is supposed to liberally apply the grids. So if someone's within 6 months of turning 50 or 55, and they would be disabled based on the grid rule that was shown to you, there is an argument that can be made for a liberal application. And then I can also send you some Sixth Circuit law, which might help. Because even though the judges are in St. Louis, these hearings would normally be held in West Virginia. The claimants live in the Sixth Circuit. And that's going to be the other thing I'm just going to say, is if you are going to take these any further, such as to federal court, if you feel like it, or whatever, please, call people. If you put something on a listserv, or call me and I'll put you in touch with a local attorney in Kentucky who practices your district. And for sure, if you're going to go to the Sixth Circuit Court of Appeals, I have extreme caution for you. That's the nicest way of putting it. I mean, we're not as bad as Bruce was talking about in Virginia, but But this is the old endocrine. And if you look here, you have diabetes right there. So that's the old diabetes listing that no longer is in effect. So this was the one that was in effect, I believe, the time most of these hearings were, because it was in effect from May of 2002 to June of 11. So really, thank God for the internet.
Deborah?
Yes.
Where are the rulings? Are they on the same page as the listings?
No, if you go back, go up search. If I could spell, it'd be nice. Oh, come on. Like I said, I have these all. Why is it not? Oh, because it's in POM still. That's why. I see what happened. I have to go to SSA.gov again. All right. That's the issue. That's what happened. And there's a list here, ruling, sequential list by year. And then we can give you a summary of what some of them are and so you know which ones to look for diseases. I'd be happy to put that up on the listserv once I figure out how to access the list now that I'm on it. That's my problem, is I was trying to do it from my phone here and it wouldn't allow me to log on.
For a lot of these, the rulings, the POMs, the HALEX regulations, also if you go to noscr.org, NOSSCR.org. Oh, okay.
You can just do that right here. Yeah, a lot of this is there. That's also if you need a cheating way to find all of us. The three of us are there if it comes up. Because we're all past presidents, so we're listed on the website. Maybe it will come. Maybe it will come up. We'll see.
At one point, it'll be sort of towards the right.
Here it is.
Okay, so legal resources, and then research for advocates. Top.
And you can do Google
You can
or
get
look
it
over here. Listings are here.
And you can do a search within the regulations, a search within the rulings.
Yeah.
One of our members made this, and it's really good.
And if you go to About and go Council of Past Presidents, there I am. An old email, because we're having too many people having trouble spelling Schifrin, including me. So we changed it to SNS Disability. I'm trying to go down. They were presidents before me. Bruce is right there, and that's the right. And
No,
then,
it has that one. I don't think this email has a one.
yeah, I don't know. I thought it did. And then I'm trying to find you, Charles. Here you are, there's Charles Hall. The other resource I'm going to tell you to check every day, because I do, and you probably won't say, Charles Hall has a phenomenal blog. It's called Soak. Oh, I keep it up on my iPad. What?
Social Security News.
Social Security News. And I will tell you that members of the administration even check his blog every day. He has sources that I don't even want to guess, and a lot of information, including he had parts of his blog in the materials you'll see. So when I looked through them, they're very faint, but he put in things that he had written on his blog. So just a wonderful resource for all of you. So I would say, I think the listserv, Charles' blog, contacting us by email is just going to be we're going to try and make this as painless as possible.
And I'll also say a lot of NOSCR members who are very experienced in disability law have offered to be resources to anybody who has a question. So in addition to posting something on the listserv, if there's a reason that, whatever reason you don't want to put a question there, you can send me an email. It's barbara.silverstone@noscr.org. It should be.
On the NOSCR website. Staff. There she is, the executive director.
So you can send me a question, and either I'll answer it, or a staff attorney, or one of our staff, or I'll send it out to a member who can answer it also. So we're all sort of in this together, and I really, really appreciate everybody's time in doing this. And we are all learning as we go about the particulars about this case also.
I'm going to also, when I get to the office Monday, is I will white or cross out the person's name and print out the forms, and I'm going to upload to the listserv copies of all the documents that, at least in this case, that I have, that we know, so you'll have an idea of what the appeals council is saying and everything else. And I figure that might be very helpful just to see what they're saying. Our idea here is we've given you a lot of information today, and there's a lot more that we could provide, but I have to feel that you're all getting kind of brain dead at this moment and overwhelmed, since we've been at it since, 8:30 this morning? And so it really is a lot, and it's wonderful that you're all volunteering to do this, because unfortunately, these people are being screwed.
I'll see if there's any questions.
So I was going to say, so any questions for myself, for Charles, for Barbara?
I have a
For
question.
Tom's back there? Yes.
I have a question.
Sure.
I'll just read it.
I'm going to close this all up. He had to go to the airport, so I see
Oh,
my
he's not
husband's-
here. Okay.
Yeah, we'll try and answer. Yeah.
I just want to thank you all for being, I want to thank you all, I want to thank you and Applered and John, because we wouldn't be here if it wasn't for your
Keep me out in the
vision and
sunshine.
passion and leadership.
It's a beautiful day.
So I appreciate, I really do appreciate you all.
Could you, for people who are new, just tell people what that electronic thing is, and you're gonna put it on the, what do you call it?
We have to-
Listserv.
Yeah, we have to find out how you sign up now, because both Charles and Bruce signed up at a conference, and I was part of there were two groups of 9, so I wasn't part of the initial 9, but I was part of the second 9. So I was on part of the Electronic Records Express long before it became available to other attorneys, because I was one of the guinea pigs that was testing it out, and still do on occasion.
So basically, we don't really know how.
Yeah, I know that I will tell you how my newest associate did it. But that's why when Bruce said he's by himself, there are 6 of us in the office, so that's why if I can't answer and don't know an answer, I'll forward an email and say, please, if I'm out, I can forward to one of my partners or one of my associates and say, please research this and answer it. She just went to our local hearing office with 2 forms of ID. She needed her driver's license and I think a passport or a birth certificate. And she made an appointment to go in, and she came back to the office with her user ID user ID, and it was done. Now, I know some other people are saying that it's been taking 2 months. You said, I believe, or someone on a phone call said it's been taking 2 months. I just know how she did it, and she did it about a year ago.
So why would one want to do that? I guess that's what.
I would say the only reason I would suggest it rather than relying on the CDs, the question is, why would you want to register for online access? First of all, it's going to be a lot easier to send in any information because you just upload it via the website once you've signed in. Second, you're going to be able to tell once your name is associated with the claim whether a hearing's been set, because there's a hearing status report that's there that you can have. And the third reason is you're going to have access to that case file. It's going to have additional evidence that may not have been marked as exhibits in these cases. So those are the reasons I would think that it's going to be worthwhile to register and have online access.
Register through the SS site?
Yes, for the Social Security.
What's the link? What's it called?
I think ssa.gov/AR.
For ERE?
Yeah, no, not for ERE, for appointed representatives.
Oh, that's online. Yeah, just look at the Social Security website for representatives. And there's various forms you can fill out online, and they're not that difficult to do. And yeah, go ahead and do it. Even if you're not worried now about attorney fees, maybe later on you will be.
But you can at least put it in and, not do the term. And if you have questions when you get those forms, send us an email, call, whatever.
Is the first document, so basically on these cases, we're going to have a notice of hearing.
Well, the first thing you're going to want to do is file an appointment of representative.
No, I know, but I'm just saying that.
Yes, you're going to get it.
Basically, they're already going to have a hearing.
Well, once you get that appointed representative, the 1696 into the file, they should call you to schedule the hearing.
Sure.
One of those for each client?
Yes. You need a 1696 for each client.
And when we enter that, even though the hearing may be 3 days after we enter, we're going to get a call from them?
What you mean, no, if the hearing's already been scheduled, but they might tell you the hearing's been scheduled. But if the hearing has not been scheduled yet, theoretically, if you've sent in that form, they are to call you to schedule the hearing.
Yeah, one thing I should say that I put on the list server, as long as somebody was on it, if you're hired less than 30 days prior to the date of the hearing, they have to give you a continuance by regulation.
If you ask.
If you ask. If you
But
ask.
30 days. If you're hired more than 30 days before, you can't do that. But if it's less than 30 days, they have no. They have to give you continuance.
And you have to do it in writing. They're going to tell everything they're going to tell you they want in writing and sent in. The other problem is calling St. Louis, the National Hearing Centers, don't have a switchboard because there is no office where it's just judges and maybe some staff. So calling them is going to be extremely difficult.
On all these, when you say submit by paper, are you talking about you can submit online?
The 1696, no, because you don't have access online till after you've been recognized as the representative. So that's why I'm saying that I would send into the local field office, and which I couldn't get into for some odd reason. And I'd also send to St. Louis, and then keep one for yourself. So if there's any questions, you have a third, and both you and the client must sign that. Yes. No.
Here's a question I get asked every day. If we represent these people and we win, why can't we get paid?
Well, the problem is someone's already been paid.
Yeah, I was about to talk about attorney fees. Actually, Ned, you're going to get paid if you win. Are you familiar with the Equal Access to Justice Act? Yeah. Okay, so you're going to get paid if you can win.
Actually, one of the civil suits against Khan, we've asked for the repayment of the $9 million in attorney fees. I'm expecting a check any day.
Well, I'm hoping you get it. You deserve it. But, attorney fees, there's going to be a lot of attorney fees in these cases anyway. not on these cases they're going before the ALJs right now, but later on if they lose. Because if they lose, these cases at that point become fee generating. You're going to have appeals from those decisions to the appeals council. At that point, the claimant is going to be off benefits, so fees are going to start to mount up, potential fees. Also on the new claims, one of the other reasons to file a new claim is these are fee generating. And don't worry about the effect of overpayments on attorney fees. Prior overpayments don't affect your attorney fee. Even though the claimant gets nothing because all the money back benefits go to a satisfying an overpayment, you still get your attorney fee.
Right.
So that's, I'm hoping out of this that there will be a stronger Social Security bar. I'm hoping that some of you came here with some interest in making Social Security a part of your regular practice, not just pro bono for a few cases here, but to make it routinely a part of your practice in the future as a fee-generating act. And there will be plenty of fees in these cases for those claimants who lose, either on new claims or on appeals, and there's certainly plenty of claims in the future because one of the reasons Eric Kahn succeeded was that he didn't have competition. He may have driven out the competition, but there really wasn't a whole lot of competition there. If there had been other attorneys in the area, he probably could not have succeeded as well. Let's get other people out there doing it. There's money to be made.
Caveat though, there's a maximum of $6,000 fee, less the user fee on each case. So I think this year it's $5,917 is the maximum you receive on a case.
And
Yes.
a lot of other forms to fill out.
You have to have a written assigned agreement by your client.
Yes, if you're going to.
Is it required by Social Security rate?
Yes, a fee agreement, yes, and I think we can send, if you call and ask rather than us uploading, we're more than happy to send you a fee agreement.
I've uploaded all kinds of things. Your mailboxes are full. I was sitting there, I've got all this stuff on my iPad that I normally carry on to hearings. You've got the Social Security Act, regulations, the grid regulations, the listings.
I was just going to say, I don't carry a laptop to my hearings, although I brought one here. I have everything in my iPad. And it's just wonderful, including I have, if you're going to do more than one, I would suggest it's worth the $50, because I checked out, it's $49.95. It's a wonderful app called Job Sleuth, and it's the DOT. Job Sleuth. SLEUTH, Job Sleuth. And it's just a great, if you're going to be doing more than one or two of these, it's worthwhile to have this because then you have the DOT in your hand at the hearing. And I check it out because I will tell you, like Bruce was saying with the hypothetical questions, and I'm going to tell you with video hearings, if you're going to have video hearings, one thing to make sure you bring out, your client walks in with a cane, say it orally. My hearing yesterday morning, my client, and it was a supplemental hearing, so she didn't testify, but in an hour and 15 minutes, she had to stand and sit about 15 times. Believe me, before we walked out of that hearing, I put that on the record. Because I want to make sure I would say, Judge, just for the record, have you noticed that my claimant has been alternating standing and sitting throughout this hearing and has probably stood about 15 times? And the judge said yes. The other thing is if people use a cane, you need to know which hand do they hold the cane. Do they need it for balance or do they need it to walk? Because if they need it for balance when they're standing, they can't use both hands to work. Those are important things. If they have carpal tunnel or other problems with their hands and are limited in how well they can finger and handle, it's going to limit the number of jobs. Or if they have, like me, I was going to say, my usual joke about severe impairment, step 2, is I have psoriasis on my hands, and I don't know if you can see, it's not as bad today, but it's still pretty bad. So my hands are, my left hand especially is real bad. That would be a severe impairment. It doesn't preclude me from working, but I have a skilled occupation, but someone else who's doing an assembly job or has to use their hands all the time, it would limit their ability to work because all of a sudden they can't use one of their hands probably more than 1/3 of the day. So those are things just to look through the records. Like I said, read the medical evidence with a fine-tooth comb. I don't know if all of you have Adobe the full Adobe. It's worth it because you can bookmark it, make notations, annotations, and I just like doing it this way. I have it right there in the file. And that's what I take with me. But really, when you're doing these video hearings, you really have to make sure that the judge is aware of everything. If the claimant's hands are swollen because they have arthritis, you want to make sure that's brought out. If the judge doesn't come on till the person's sitting down in the hearing room, you want to bring out, well, this person walked in with a cane or they limp. Because you're going to be probably with the claimants. Those of us who are going to be doing them via the three-way, as Charles said, is we're not going to be in the room with the claimant. So those are things I'm going to want to talk to the claimants. I will tell you my practice is besides meeting with the, meeting and talking to the client when they first come into our firm, my pre-hearings for my October hearings, which we've already assigned, are all next week. Because I have no hearings next week, so I'm doing pre-hearings all week. So I will be meeting with each of my October hearing people, because this way I'm meeting with them far enough in advance that I can know if there's anything additional we need to request. And I have that benefit because they're set for October. I mean, I don't know if we're going to have that benefit with these. But then I also talk to them again the week before the hearing, and then I just call them and just say, listen, remember your hearing's coming up. Do you have any questions, concerns? Has anything changed since we met? But I make sure I meet with their client if at all possible. Or I know the offer, I'm not sure who made the offer for us to do video conferences with the claimants in their office, and then we could talk to them that way. Because I'd like them to know that, yes, this is the face that will be coming to the hearing or representing you, and I'd like to see your face. Other questions? You really have made your brain dead.
One thing I was going to say is, there's no way in a day CLE that we're going to make you have the kind of experience that Bruce and Deborah and I have. That's going to take a few years. We're going to try to get you to the point you're 90% or whatever. Don't worry about it too much. You're not going to be aces at cross-examining VEs. There's no way. I'm not even sure we should even try and train you on that. You can you can do a hearing without doing that. Do the best you can. If you just get them to file new claims, if you get them to show up for the hearing, if you get the new medical evidence, you're going to be like 99% of what needs to be done, and they're going to, you're going to make their lives a whole lot better. You're going to get a much better chance of being approved then or being approved on a new claim. You're going to prevent the suicides that have happened and that may happen. Just do the best you can and ask for advice on the listserv, and you're going to get a whole lot of advice. You'll get through this. You may not feel like you're too secure on it, but you'll get through it.
And the other thing is that my old evidence professor always told me, know when to shut up. So if the answer to the first hypothetical that the judge poses to the vocational expert is no jobs, do not open your mouth. That means that's it, and the judge doesn't ask any other questions. That's the evidence in the record that there's no jobs. And you'd be surprised how many attorneys then will ask hypothetical questions.
And if the ALJ doesn't even ask any questions of the VE at all, shut up.
Yeah.
You just won.
I'm saying either way, you won. Or if there is a medical expert and the medical expert says your client meets or equals a listing, thank you, doctor, I appreciate your testimony. So that is a big key that's different than any of your practices. So those are the types of things that, like I said, we're all more than willing to help. I know that as of the other day, there were 33 NOSCR members, I think, already on the listserv. So pose questions, someone will get back to you. Or just send, like I said, I'm always willing to answer an email. Thank you. Any questions for the report?